What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy Wednesday. Hopefully you guys had a great start to your week. I did. Hopefully you did too. Anyways, you guys want to watch some court? I want to watch some court. Let's watch some court. I've got one case tonight, and we've got a long one. This is about a 2-hour trial. This trial should only be about 15 minutes. And every single party draws this thing out. You are going to be laughing. You are going to be frustrated. You're going to feel all sorts of emotions in this one. It's wild. It's wild. And there's a moment. There's actually a few moments where you're going to think the tenant is trying to pull some soft sit stuff. Yeah. So welcome to tonight's stream. I am most likely going to be breaking this up into 2 videos. I do not think I can go for 2 hours straight, but we'll see. We will see. As you all can see, I did post No-No's GoFundMe link. His sister finished the GoFundMe page for him. So as promised, the GoFundMe is there. If anyone's already donated, I've already given the money to him. You don't have to donate a second time. I respect you. You don't have to do it again. But there were people that are asking for the GoFundMe because, it's weird sending someone money and then for me to just give it to him. I get that. But it's there. If you want to donate, he could always use the help. Also, if you looked at my community post today, I posted the card link. I guess I can post 2 links. I just don't want to confuse people. But the digital card is available if anyone wants to sign that as well. So there you go. Yeah, that's all the time I'm going to spend on that tonight. I feel like I've kind of drilled that into your head, so you already know what's going on. Specs, thank you so much for the super sticker. I appreciate it, bud. Good to see you tonight. I do appreciate it. All right. Now let's watch some court. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. This one's going to be fun. Let's go.
I think the concluding matter now, and please correct me if I'm wrong. Let's see. I have to handle the matter involving cause number J4 CV 26004177. This is TRG TCHFC Austin Gateway Mixed Income LLC doing business as Cedar Heights versus Nicholas Hake and Jaden Ruse. All right. And I have an attorney representing the plaintiff. That would be you, Adriana Higginbotham. Thank you.
Yes, Judge.
And you have a witness by the name of Mary Mendez.
Yes, Judge.
And you're with the law firm Hoover Slovacek. All right.
Yes, ma'am.
Okay. Understand this is a little more complicated simply because there's some pretrial motions pending. So I want to review what's going on with that. The only thing that my staff has been able to copy for me, and I'm looking at, is the defendant's motion for status conference and pretrial case management hearing. I'm not sure that I'm in a position to do any of that, but understand that there's a plaintiff's motion for summary disposition.
Judge,
that
we're willing
correct,
to pass
Mr.
on
Butler?
that. Yes, Judge, that was filed, but we will pass on that to be able to proceed forward with trial
Yeah, because
today.
we don't do summary dispositions and evictions. We have the trial and we rule. That's it. I mean, there's just no time for me to make decisions that there's no, because there's rarely a case that involves no disputed facts. Okay, so in the future, you should refrain on an eviction case from filing motions for summary disposition. You're just delaying your case when you do that. Because these are all we move forward, we move quickly. Okay, so you've withdrawn your Are you gonna wait?
Biggin Raid. What is up, Biggin Raiders? Thank you so much, Biggin. You guys came in right at the start of the show. Thank you so much. I do appreciate you all. Thank you so much, Biggin, for the raid. Hopefully, you guys have had a great evening so far. There's nothing really to explain here. We just started. This is a landlord-tenant case where the tenant, our dude in the bottom right-hand part of the screen, he tries every defense possible to get out of paying this. It's going to be a long one, so buckle up. But Biggin, you are awesome, man. Thank you so much for the raid. And you know what? I meant to message you this morning to ask to update me, to get an update on your channel. I'm sure the chat will update me now since I haven't spoken to you. But hopefully everything's going okay with you with getting it back. You may have already gotten it back since you just raided. I hope so. Also, Rix, thank you so much for the 14 months, my friend. I appreciate it. Thank you for all the support. I do appreciate it. Hopefully you're having a great night.
Withdraw the motion. Is that what you're doing at this time?
Yes, Judge, we'll withdraw the motion to proceed forward with trial today.
All right. All right. So now let me get to Mr. Hake. What you say you have, and this is, I'm reading from your document, all right? Because I have to open up the file and start looking at all these, but you introduced to the court that something about failure to receive original case materials having to do with the original petition, the motion for alternative service, the order authorizing alternative service, a complete set of the pleadings and exhibits filed in this case. Okay, so let me just make a statement about that as the judge. That all sounds like something you're raising to dispute or to contest whether you had if there's been proper service in this case. Well, I'm going.
Mary Smith, good to see you this evening. You are the saint of the evening. That's all I'm going to say. I do appreciate you. I sent you a message on Discord. You are absolutely amazing, by the way. So awesome.
Going to just overrule all that right now because by your appearance and you filing motions, you've entered an appearance for all purposes that waive.
All right, sorry for the multiple interruptions. Can one of my mods put in his Biggin's new channel link? Let's push that link tonight to let's get his subscribers back up. And I still have faith he's going to get his channel back. I really do. I've seen people get hacked before they get their channels back. So hopefully he gets it back. But you know what? Why not? Let's just build up his new channel while he's trying to figure it out. So if one of my mods can post that, please, and have everyone just jump over there and hit the subscribe button real quick. I would appreciate it. He would appreciate it.
All objections to
Miss Biggin would also appreciate it. Love that picture, by the way.
when and how you may or may not have been served. You're before
Yes,
the
Your
court.
Honor.
I have jurisdiction over you. We're done with that, okay?
Yes, ma'am.
So I'm not
Can I make one
considering
notice
any
real quick,
issues
please?
involving how you may or may not have been served. You're before me. I have
ma'am.
jurisdiction over you.
That's completely fine. Can I just make one quick request? Can I be
Sure.
emailed the original filing right now? I literally just quickly emailed it. I'm not asking for disputing service or method service. I'm just asking if you guys can just quickly, even Adriana or the court, if you guys can just quickly email that to me like right now, the filing, that'd be greatly appreciated. I just never received
So
that.
you've never seen any of this?
No, I called in
You
because I
did there by
expected them.
yourself? I read something where that you were traveling when all this started happening or something.
Yes.
Were you just not present, were unable to see it? But you also admitted that
Mhm.
you accessed all these all this is online. You can access and look at it. Have you seen everything now?
The filing, at least from what I could find, I couldn't find the filing. I assumed that they filed because we've actually had a previous case with this. The previous one was dismissed, so I assumed they were going to refile.
Okay.
Oh, stop lying. That was last year. Stop being humble. You guys look great. You guys look great. That was last year. Don't do that. You know, you're allowed to be awesome, and you don't have to be humble as well. Just keep being awesome. Keep being you. You're awesome, Miss Ping. Good to see you tonight.
So there's been a previous eviction involving the same parties. When did
Yes.
that occur? Because that's I kind of heard about it, but I try to tell the staff, don't tell me anything. I want to hear it all in the courtroom because I'm
Yes,
a
ma'am.
visiting judge. If I was the regular sitting judge that might have known about it,
Yes, ma'am.
I don't want to be told anything about it without the parties being present and me hearing about it. So I heard there might have been a prior case that might have been dismissed, but I didn't look at it. I didn't open up old files. Obviously, you're confirming that for me now, what the staff said to me, but I don't like to be affected by looking at old files unless
Yes,
I have
ma'am.
to. If I was the sitting judge here and was privy to it because I was sitting here all the time, I'm a visiting judge today. I would have already gone and looked at that file and what had happened in it, but I have
Yes.
not looked at it today. But
Yes,
I
ma'am.
was told that it existed, and I wanted to say that to both of you in front of
ma'am.
me. But I'm not affected by anything I might have seen or could have seen in a file because I just refused to look at it. Okay,
Yes.
so what do you want to say to me about that prior filing now that Ms. Higginbotham is present?
Yeah, I just wanted to quickly say that the only reason I knew about this case is because I received notice to vacate. I assumed, based on reasonable knowledge, that they would file after that notice to vacate period was up. So I called shortly after that period. I called the court. I asked the court, did they go ahead file? They did. The court clerk did confirm that they filed. She also provided me a case number. I did do my research online. I could not find the original filing. I'm just asking, like, I don't need more than 60 seconds to review the original filing. I just would like to just see the filing, because I haven't seen it. I've just been going
Okay,
off
so
of,
you've received the email already or not?
I haven't received, I can check my email real quick if they
They
just sent
sent it
me.
to you yesterday. You didn't look at it last night, you didn't look at it this morning.
I did not see that it attached to that email yesterday because I did not see that. And if so, that is on me.
It was an attachment? The citation and petition.
Okay, let me verify that is on me if I did not see that attached.
Well, that's not my fault that we sent you
Um,
something yesterday and you
yeah.
haven't looked at it and you're asking for time to look at it now.
I can screen share real quick. It was not attached to that email.
Me, it
Yes, Ms.
appears
Higginbotham.
that the
Oh, I just got a little internet glitch. Can you guys hear me? I got the little spinny wheel of death. Hopefully everyone's here with me. I'm gonna wait till I hear we're all good before I hit the play button. We all good? Yep, we're good. Okay, perfect. And while I am paused, no, Alexander, you're good. You're good, man. Sorry, you're good, man. You're good, my friend. I guess I should say. You hang out a lot. I didn't take anything you said negatively. You're good. You're good. Otherwise, I would have paused it and gave you crap for it because I usually do. But no, you hang around a lot, so I understand that you're just trying to be, let me know what I'm doing. But since I am paused, Terrapin, thank you so much for the 21 months. I appreciate it, my friend. Thank you so much for all the support. Thank you.
original petition was actually served on Mr. Hake by a constable on 7/20/26.
I've been in Washington State since June 24th.
All
And
right,
I
I'm
am
gonna ask
still
the
in
staff to print out for me the return of service, both on you and the other tenant. It might have been on the other tenant. Oh, who is this, Mr. Roos? Roos?
He has not resided in Texas since March of 2026. He is a resident of Michigan.
Okay,
was
so
a-
he would not have been present to have received service. Is
No, ma'am.
anybody else residing at those premises in your absence?
No, ma'am.
Okay, so I'm going to have the staff, Ms. Higginbotham, right now, they're gonna print me out the return of service I received from the
Yes, ma'am.
constable. He'll tell me exactly, or his deputies, how it was served. This could have been alternative service, Mr. Hake, you understand that?
Online it did say.
Alternative service is
alternative.
legal and valid, whether
Yes,
you
ma'am.
were there or not.
No,
They
I'm
can
not.
leave it- After they make a certain number of attempts, they ask permission of the court whether they can use alternative service, which we typically grant without objection as the court.
I'm not
And
disputing
then,
the
and then,
validity.
then it gets served by posting on the door and mailing it to you. Whether you're there or not, it's not our concern.
Yes, I'm not disputing the validity at all. I'm just asking if someone can send me the original filing. That's literally all I'm asking because I
All
have
right.
not seen it. Is
Okay,
that
Ms.
potential by anyone?
Higginbotham, Mr. Hake, I need a bathroom break.
Okay.
So we're gonna pause for 5 minutes.
Okay.
while they send him the pleadings, because we're going forward with the trial today.
Yes,
That's
ma'am.
all I have to say about this, okay?
Yes, ma'am.
All right, thank you. We're in recess for 5 minutes.
Thank you, Judge.
All right, have you had a sufficient opportunity to review the original petition, Mr. Hague? Can y'all hear me?
Yes,
Yes,
I can.
Judge.
Okay.
I still haven't received it, but it's fine. We can just go ahead. I can do without it. It's fine.
Okay, Mr. Hick, I understand. I mean, I just can't believe what you're telling me, that you can't access these documents on site, online with the court. Any
I understand.
litigant can do it.
I understand. I don't know.
Are you familiar with that?
I am somewhat. It's fine. Honestly, Your Honor, I'm willing to just
All right,
move
and this
ahead
emergency motion,
ignore it.
that
I
you've
withdraw.
been online, that you've been waiting, that you had this business, this important business opportunity. When you're in court, look, I've been on the bench
Understood.
since 9 o'clock.
Understood. I withdraw that motion.
No, whether you withdrew it or not, I'm denying it. I'm just denying it, okay?
Yes, ma'am.
We're gonna proceed, and we're gonna finish this, because when I come work for Judge Gonzalez, I don't like to continue anything, because
course.
that's not my role as a visiting judge. I'm here to do the work that's before the court on the day I'm here, and I don't like to dump anything back in his lap. We're going to trial. We're gonna finish this case.
Yep.
All right. Because that's the way I felt when I was the sitting judge and I had a visiting judge. If I had a matter, I would have preferred be resolved, and then it ended up back in my lap. I was not happy about it. So I don't do that to judges that I've worked for as a visiting judge. All right, Ms. Higginbotham.
All right, that is one of that might be the first monologue we get from Judge Diaz. She is going to try her best to beat Judge Rossi on the judge who talks so much. She's going to try. When I said at the beginning of this hearing or this trial that all the parties make this trial last 2 hours and it should only be about 30 minutes, yeah, she's a party to it. she does her best to make it last as long as possible. While I am paused, though, Cheshire Cat, thank you so much for the super chat. Okay, so don't touch that. Got it. Appreciate it, bud. Good to see you tonight. Mac the Knife. Hold on. Pull it up. Mac the Knife for 23 months. Thank you so much, Mac. And good to see you this evening as well. Thank you, bud.
I'm going to, can you print me out the original petition for me? I'm going to let you present an opening. Well, let me make sure I've got all these pretrial matters taken care of. Motion for summary disposition is withdrawn. The objections to service and lack of service was waived by having appeared, your appearance by filing documents and appearing here today, waived any objections to the validity of the court's jurisdiction over you for lack of proper service. The motion for continuance is denied, and we'll move forward. I think I've handled everything that's pending and outstanding. All right, so the first thing I'm going to look at, Ms. Higginbotham, before you begin your presentation, I said to the staff, let me see the certificates of service filed by the constable's office.
It's a landlord-tenant case for unpaid rent. That's all we're here for. Something that shouldn't last 2 hours.
Because you said you never got served and you never got the paperwork, Mr. Hague. Here's the officer's return. Came to hand on the 16th day of July, 2026 at 10:21 a.m. Executed at 2:07 p.m. the 20th day of July, 2026 by delivering a true copy of the citation together with the accompanying copy to the petition, having first attached such copy of such petition to such copy of citation and endorsed on such copy of citation on the date of delivery to the defendant, Nicholas Hake, and all occupants. The service was executed by Rule 510.8, parentheses, small letter E, parentheses closed, by attaching to the front door and mailing the copy by first-class mail on the 20th day of July, 2026 at 3330 402 Austin, Texas. So they had to use alternative service because they could never find someone that would answer the door. And it's all permitted by law. And your service complaints, like I said before, are waived by you having appeared in this case. Ms. Higginbotham, I'll turn it over to you for
Thank
your
you,
opening
Judge.
statement.
Yes, ma'am. Just a brief opening, Judge. I'll keep it as brief as I possibly can here. This is an eviction for non-payment of rent. Mr. Hake entered into a contractual agreement with the property for the address of 3402 Austin, Texas, 78744, with the lease commencing on or about January the 9th of 2026. Based on that lease, Judge, the monthly rental is $1,850 due on or before the first each month. At the time Mr. Hake took possession of the property, he was obligated to pay 23 days of rent because he moved in after the first. So he was responsible for 23 days of rent, as well as an $800 security deposit to be remitted to the property. He did make both of those payments as of January the 10th. One of the payments, specifically the $800 payment for the security deposit, was returned NSF. Mr. Hake then resubmitted that security deposit payment again on January the 14th, 2026, which was then returned NSF. It's important to note, Judge, that the property has no ability to input individually themselves, nor can they manually override a NSF that's put into the system or a return payment, as those are directly pulled from the banking system. The ledger system and the banking system run together. So when an account or when a payment is returned NSF, it will automatically reflect in the ledger. Additionally, Judge, at the time Mr. Hake took possession of the property, he moved in on a special of 10 weeks free. That means that
Yeah, if you find the key card in the other room, you can actually unlock her desk for special ammo. But other than that, it's just normal loot. There's nothing exciting in that desk.
rent for the month of February and March were covered in full in the amount of $1,850, and April was covered in half. So that means only $925 were owed for April.
10 weeks of free rent? Okay, I know
Yes.
this is just your opening statement, and then I'll get more testimony about that from your witness, but, so they had 2.5 months of
Free
like a
rent.
bonus, a move-in bonus, basically.
Right, like a concession. Yes, ma'am.
Yes.
So he didn't technically owe rent until April of 2026 and the amount of $925 plus, the normal fees, sewer and all those things, right? But rent only $925 for the month of April.
Yeah, I know contractually, there's other things involved when it's not paid on time, there could
Right.
be late
Late
charges, yeah.
Yes, ma'am. Yes, ma'am.
Now,
Heather.
let me ask you one thing before you proceed,
Yes, ma'am.
and you may get into it with the testimony of your witness. Is there a provision in the lease agreement for a loss of the concession?
Yes, there's a provision for
What do you know? Because I knew that that's, I've seen this in the past,
yeah,
where move-in free, free rent for a month or two, and then in the end, even though they start paying on time, when they finally default, maybe 5, 6, 7 months later, they lost the concession
Yes.
because then whenever the non-payment of rent occurs. Is
exactly,
that
Judge.
yours the same? All right,
Yes,
I
Judge.
just wanted to ask that question. Whenever there's a concession involved, I always want to know how the lease deals with it. Okay, go ahead.
Yes, Judge. Yes, Judge, you're right. It does state that in the lease, as well as the concession addendum that's attached to the lease.
Okay. Oh, you have a
Additionally,
separate concession addendum. All right.
yes, Judge. So it's referred in the lease, and then the concession refers back to the lease as well.
Okay.
Yes, ma'am. Also, Judge, in the concession agreement, Mr. Hake was entitled to a 2,000 concession for the month of May. So he had two concessions, one 10 weeks free, and then another one for $2,000 for May.
Judge is a pro temp judge. She's working by the hour right now. She's just trying to make these hours count. Why take a 30-minute hearing where you can make it 2 hours? Get paid for that. Yeah. I don't know how that works. That just seems that you guys are going to feel that here shortly.
These are all contingent upon him complying with the terms of the lease. So today we are seeking rent for the month, even though he has waived, the concessions are considered to be waived at this point and voided out. We will be seeking that $925 for April, Judge, and then the $1,850 for June, as well as July. We do have, yes, ma'am, that total amount, Judge, if you need it, is $4,625.00. That is at $925 for April, which is one half of April, one full month for June, and one full month of July, both at $1,850 each. Judge, we do, and I believe they're attached to the original pleadings, all of our exhibits, including the documents showing that in our system, there is no security deposit, which was the start of all of this. The security deposit was not paid. There was multiple.
So is that a lease violation that's part of this case?
It is.
Is that an
No,
alleged
Judge,
lease
it's not a lease
violation?
violation. No, Judge, we didn't include that as a lease violation. We're just going for rent, not
Okay,
for.
so in other words, you haven't pled that, but you're just telling me.
Yes, Judge, just a little background so you can kind of know what happened, what started all of this. The parties tried to work with them, with Mr. Hayes.
What was the security deposit, what was expected that you say at this point is unpaid?
$800, Judge, which again, Mr. Hayes remitted payment on the 10th of January. It came back NSF, and again on January the 14th.
Oh, okay, those were the
it was
NSF
returned.
checks, okay.
Right, the security deposit came back NSF. There was a lot of back and forth with Mr. Hake on that. At some point during this, I believe it was in the month of April, we asked Mr. Hake just remit the payment, your payment for your rent. We'll figure out the security deposit. That wasn't done. There was mention of a prior eviction proceeding, Judge, and there was Judge Gonzalez actually believed that our notice to vacate.
And when did that other eviction occur? Was it right at the time when the security deposit issue was happening?
Judge, that actually occurred months later.
Obviously, at that point, he was still under this concession.
Right. No, Judge, that didn't happen until April.
That was,
okay. Yes, that was after his one half of the rent was due and it was not paid. Okay. And that is also when the management went in.
The 925 that you're seeking in this trial, this eviction, was there a dismissal? Was there a judgment for the defendant for maybe some failures with the method of service? I mean, what was the deal? How did that particular eviction end?
We non-suited that, Judge.
Okay, so you non-suited. All right, then.
And then we reissued a notice to vacate. We reissued a notice to pay or vacate to comply with the new revision.
Some notice to vacate issues. So right. In light of that, you just non-suited and
right, and we started over.
That's fine. Okay, that's all I need to do.
So, Judge, we're here today just seeking possession, even though the concession is void at this point, and we're allowed to void it under the lease. We're only seeking, in accordance with the concession, that one half month of rent for April, $925, as well as June and July, full months of $1,850. That total payment, Judge, I believe I gave you that number, was $4,625. They did reissue a 30-day notice to pay or vacate as of June the 5th. Still to date, they have not received any payments.
Okay, let me get back with you one more time on your opening statement.
Yes, ma'am.
You said there was a second concession?
There was a second concession, Judge, for the
could have taken in, could have happened, but it hasn't.
Right, Judge. So, but
it did because you're not looking for it today.
Right, we're not looking for it today. We're only asking for.
You're basically in terms of a monetary judgment, you're just seeking the rent he could or should have paid through this time.
Right.
And you're not seeking to reverse the concessions and seek that as unpaid rental at this point. Obviously, right. It's not like you're giving that up. Contractually, you have an addendum. Right. You can have a separate lawsuit later, but it's not muddying up the water today.
Right. Yes, Judge. It's not muddying up the water today. You got it exactly right.
You don't have to repeat everything the attorney says, Judge. You got this. We have faith in you that you can handle this matter without breaking it down. I think that's my job. I do.
Yeah, but this is not a waiver on your part of the possibility to proceed in the future.
Exactly, Judge. It's not a waiver. We're just only seeking a monetary judgment for the rent that he should have paid if he had fully complied with his terms of the lease.
All right, thank you.
Thank you, Judge.
All right, so Mr. Hake, you're entitled to an opening statement at this time. If you want to make one right now, because obviously Ms. Higginbotham is not testifying. She's the lawyer. She has a witness that's she's going to she's going to put all these facts before the court through this witness in just a few moments. However, you are the only one that would be testifying. So in the event that your opening statement may include some factual information that kind of you can't keep separated because you don't have a lawyer speaking for you, I'll swear you in and then I'll take it, because a lot of people like for their opening statement to follow the opening statement of the plaintiff, just so that I have both sides in my head before I start hearing the testimony. So, Mr. Hake, do you want to make your opening statement now, or do you want to reserve it until the plaintiff rests?
I just have a quick disability statement first, and then I will rest the rest of it. I just want to provide notice that I have communication-related disabilities, including autism, ADHD, and anxiety disorder, which affect my processing speed and verbal communication under pressure. I have prepared notes to assist me. I respectfully request reasonable accommodation to allow me additional time to review information, organize responses, and reference my notes when necessary so I can accurately present my case.
That's
Just
fine.
wanted to, yep,
That's
I just
fine.
wanted to
You
mention
need a
that.
little time to absorb something, to respond to something.
Yeah, I don't know what to say about that because I don't want to hurt anyone's feelings, but those are things you don't have to tell the court. You can just say, I need a minute, judge. And that's it. I feel like he said that. He put it on the record just so it was on the record so he can use that if he's going to appeal this. I think he was using it as ammo. I don't think he was using it as anything else besides that. Because he does fine. I've watched this entire 2 hours. He does fine.
Just say to me, Judge, can I have a minute? Can I have 2 minutes? Whatever you think you need to organize your thoughts.
Yes, ma'am. I appreciate
I'm not familiar with ADA requirement for accommodations in a courtroom, but it's not anything that would affect me right now in giving you that time, so I don't have any problem with it. Ms. Higginbotham, do you?
No,
all right.
Judge, I don't.
No one's gonna have a problem with that. No one's gonna admit to having a problem with that. Pamela, thank you so much for the super chat. I appreciate it. Hi, Colin. Love your channel. Watch faithfully and finally cut live. Hope everything is well. Everything's awesome on my end, Pamela. Hopefully you're having a great night as well. Hopefully you are. And thank you so much for the super chat. I appreciate it.
All right, well, let me swear you in then, Mr. Hake, so you can make so you want to make the opening statement now, or you want to reserve it till the plaintiff rests her case?
I'll make my opening statement now.
All right, please raise your right hand and be sworn. In the event that your opening statement has some factual issues, I want you to be under oath. Do you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do, yes, ma'am.
Thank
Yes,
you.
Your Honor.
All right, thank you. You may proceed with an opening statement, which is your summary of what you think this case will be the resulting factual information that will be received by the court in this case when both you and Ms. Higginbotham are done with presenting the actual facts. But right now you're giving me a summary of what you expect your defense to be, and then we'll proceed.
Thank you, Your Honor. I will do my best to clearly explain the summary and provide the court with that document and evidence supporting my position. The case arises from a dispute regarding the amounts allegedly owned during my tenancy at Cedar Heights. The primary issue before the court is not simply whether rent was owed, but whether the plaintiff can accurately prove the amount they claim is owed. From the beginning of this tenancy, there was inconsistencies regarding the financial terms. I applied for the apartment on December 24, 2025. I was initially informed that move-in would occur around December 29th, 2025. That date changed, then changed again to approximately January 5th before I ultimately moved in on January 9th. Before moving in, I was verbally informed that the prorated first month rent would be approximately $1,100. There might be some odd dollars difference. However, after the dispute began, the plaintiff has presented different amounts and calculations repeatedly that do not match that understanding. The plaintiff's own allegations contain multiple conflicting figures. In one section, they claimed 1175 was owed for a deposit. In another section, they claimed 1850 in rent was required for prorated rent. Later, they referenced a total amount of 2172. These amounts do not clearly reconcile with each other. My position is not that a landlord is not entitled to collect amounts properly owned under a lease. My position is that the plaintiff must prove the amount claimed with accurate records and consistent accounting. Throughout this matter, I have disputed the calculations because the amounts keep changing, the accounting is unclear, and the plaintiff has not provided a clear explanation showing how they reached that final amount. The evidence will show that the case involves disputed facts regarding the agreement between the parties, the amounts charged, payments made, and the calculations of damages. In addition, there is concerns of a statutory retaliation, and I would like to raise a statutory retaliation defense under Texas Property Code, Chapter 92. But
Did
I
you
think
file a written answer to raise it?
yes, it should be all listed in my original answer
I need
that
that.
I filed. I filed the original answer to the summary disposition, but I didn't get that original filing, so I didn't file any other original answer.
All right.
But
Well,
it's in my evidence too.
okay. Now you understand. I'll have to see your answer to see how you're how you're raising the possibility of there being some retaliatory action taken on the part of the plaintiff against you. But it has to be based on something you did, something you said,
Hey, we're not gonna play that game. If you said something that one of my mods didn't appreciate, then yeah, I will back them before I back anyone else. So yeah, we're not gonna call out mods for a comment that was, removed. That's it. That's all I'm gonna say. We're gonna move on from this. Everyone's good. Michelle, I like you. Everyone's good. We're gonna move on from this. We don't need to talk about this anymore in chat. Come on. We got a video to watch. Let's have some fun.
complaint you made and their reaction is in response to something you did. So I can look at that. I'm very familiar with
Yes, ma'am.
retaliation. In fact, I
Yes, ma'am.
had a case involving a jury trial years and years and years ago
Mhm.
where plaintiff represented by counsel came up against some defendants that were representing themselves, and they managed to convince the court and the jurors that there had been some retaliatory action taken, but it was all based on requests for repair.
Yes.
Yeah.
For
You
me,
know,
it was
You make a
TLR
request
related.
for repair, and they start trying to get rid of you. It's like that
Yes, ma'am.
classic slumlord. That the
Yes,
minute
ma'am.
tenants start asking for
Yes, ma'am.
repairs, they go, okay, well, you gotta go. We're gonna evict you. We're gonna get rid of you. And
Yes, Your Honor.
so
Yes.
I'm very familiar with the retaliation statute,
Mhm.
and we'll see how you
Yes, Your Honor.
you can manage to convince me
Yes,
that
ma'am.
something you did or said or reported or didn't report was followed by. Are you saying that the action of the filing of the eviction itself was retaliatory? Because that's very rare. Because
So
if
what-
there's non-payment of rent,
Yes, Your Honor.
evictions are not retaliatory, okay?
Yes, ma'am.
All
I
right, so,
understand.
but I'm gonna
Yeah, it's
look.
related
I'll
to
look- I'll be
TDLR.
looking at the pleading, but I'm gonna let Ms. Higginbotham call her first witness, and I'll
Okay.
hear her establish everything she told me she'd be establishing.
Yes,
Thank you,
Your Honor.
Judge. Can I make one?
All right, this is a good point. Yeah, Michelle, I didn't say you did anything wrong. I don't know what happened. I'm just saying let's just move on. Something was said that one of my mods didn't like, if that was the case. But I'm not calling you out. I don't know anything of what happened. I'm just saying let's move on. Let's if it was one comment, we're not gonna let one comment ruin our night, right? We're all gonna have fun. I like you, Michelle. Crazy cat lady like you too. I'm not harassing anyone. You know what? You go. Just go. I'm not harassing anybody. All I'm saying is let's just move on. But if you're taking a hard line in the sand, fine. I will back my mods. You can leave. I don't care. Harassment. All I'm saying is let's move on. And you guys are being like this. Okay. All right.
Comment about the retaliation before we
Yes.
Judge, I understand Mr. Higgs' position, but like you said, 92.332 clearly lays out non-retaliation. Non-payment of rent issues are non-retaliation. So
Exactly. That's
Yeah.
what I just wanted to make very clear to him. The
Yes,
minute that there's a non-payment of rent situation,
Mhm.
any eviction they file with respect to non-payment of rent is not retaliatory.
Yes, Your Honor, I understand. It's a
All
little bit
right.
complex.
Okay. Then you're not going to convince me otherwise. All right. Go.
Thank you.
It has to be something
Hmm.
more like, I needed this repair. I made a complaint to the city.
Yeah, and this isn't Biggins' channel. Bye.
I made a city code violation complaint. Then they started attacking and trying to get rid of me.
Your Honor, may I make one quick thing real quick? And obviously this will be discussed more in the trial, but the payments that they allege that I did not pay at the time of the notice to
The
vacate.
security deposit NSFs.
Yes.
Okay.
There was 3 times paid the 800, 2 NSFs returned. So therefore, the third one was it's on your guys' resident ledger, listed here. Oh, it looks like my blurring thing won't let me show you, but it's on your guys' ledger. It's listed the row 3, row 5, and row 7 of the ledger.
Okay. Well, the only
Yeah, of course,
reason,
sorry.
obviously, they're not evicting you for, well, or did you say, Ms. Higginbotham, you included non-payment of security deposit as another reason for eviction?
No, Judge, that's not included.
That's not an issue here. Yes, she
paid-
talked about it. Yes, she introduced the concept. Yes, she alleged that this is what started the disagreements between the landlord and the tenant because there was a failure to pay a security deposit. But that's not what they're evicting you for.
That's not
Okay.
what they told me, though. That's the thing. The notice to vacate was issued before any rent was due. It was issued on March 23rd. They themselves said that no rent was due until April.
I
So
know, but that was
therefore-
for the old eviction, wasn't it?
Yes,
Yes,
Judge,
but
it was
this
about-
entire
Proceeded.
thing.
Obviously, they knew that they had some issues, and that's why they non-suited the first case. That first case is not before us.
And they
This
told
is
me
the
that I
new
couldn't.
case. This is a case based on non-payment of rent.
I
Yes,
understand.
maybe there was an issue, and maybe that's the reason the non-suit occurred, because they had an issue with suing you for non-payment of a security deposit. And then I hear what you're saying. I hear that based on their own ledger, you see that a payment of 800 was made 3 times, only of which 2 were NSF. So you're trying to say right now that you probably do have a security deposit in their possession that belongs to you.
Yes
Right?
and no. Yes and no, Your Honor. Their current notice to vacate, the most recent one, does mention security deposit, as does multiple communications with myself.
Judge, we're bound by
So-
our pleadings. It's not included in our pleadings. It was referenced in the notice to vacate as that's the issue that we did have with Mr. Haight. But our pleadings are only for the payment of rent and violations under, what sections is it? I'm sorry, Judge. I'm not going to plead.
And
Okay, and Mr. Haig, the issues before the court are confined between the 4 corners of a pleading. If it's
okay.
not in the pleading, she can't present it unless she moves to amend her pleadings in the middle of trial.
Question, does
So
an
if there's
exhibit
no, if there's
count?
no pleading that involves a security deposit, we're not gonna get into that right now, okay?
Okay, so an exhibit
I mean, if
wouldn't fall into that?
if they end up, if you end up being evicted, if you end up having to move out, if they say that they don't have a security deposit for you, then that'll be an issue for you to sue them and sue them for triple damages if they fail to account for and return a security deposit or any balance that may be due. You might
Understood.
have a cause of action for a security deposit, but it is not an issue here today. The issues are are governed by the pleading filed by the plaintiff, and they are not suing for non-payment of the security deposit. That is not an issue. It's not within the four corners of the pleading of the plaintiff, and that's not before the court. But that's not to say that you haven't found that in fact they do have your money. And if they don't return your money or give you an accounting for that money, 30 days after you have vacated, you may have a lawsuit that includes triple damages and attorney's fees plus $100 for willful handling and not returning your security deposit. So heads up, Ms. Higginbotham, okay?
Right, and
That's
Judge,
deposit, and that y'all better make sure that you don't have it in your possession, because you're gonna have to deal with it within 30 days of him
Yeah.
vacating the premises, if that's what happens here today.
understood, Judge. We don't have a security deposit. I just checked the ledger, just so you know.
All right, well, it says that it shows a payment 3 times and only two NSF, so.
Yes,
what's
sir.
the-
One is, yes, ma'am. One was for rent. That's what that other 800 was. It's not for a security deposit. Okay, Judge, I'll call Miss Mary Mendez briefly.
All right. Ms. Mendez, please raise your right hand and be sworn. Do you solemnly swear or affirm the testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Miss
All right,
Mendez,
you may-
Pamela, thank you for the super chat. I appreciate it. And this one for perfectly dealing with the unnecessary drama. Love you and the mods. My mods are awesome. I will back them. I don't care who you are. If you say something and my mods remove it, just move on. That's all you have to do. I have a list of rules that they all follow, and they do an amazing job. So I will absolutely back them before anybody. So yeah, just accept it and move on. That's all that had to happen there. And now we have, weird feelings. JP Jazz, thank you so much for the 5 gifted memberships. I appreciate it, bud. Welcome to the 5 new members. JP Jazz, you are awesome. Phil also dropping 5 gifted memberships. Thank you, Phil. 10 new members. Welcome to the 10 new members. Thank you all. All right, let's get back to some court.
proceed, Ms. Higginbotham, with your examination of your witness.
thank you, Judge. Ms. Mendez, you've already been identified for the court today. Can you please state your affiliation with the plaintiff, Cedar Heights Apartments?
I'm the property manager.
And are you personally familiar with the facts involving this case with Mr. Haig?
Yes.
Alrighty. On or about January the 9th, is it accurate that Mr. Haig took possession of the property in accordance with the lease that he signed?
Yes.
Okay. And is it accurate that the property was 3339 Casey Bridge Court, apartment 3402, Austin, Texas, 78744?
Yes.
At the time of move-in, was Mr. Haig responsible for his rent as well as a security deposit?
He was responsible for the proration of his moving, the rent, and then his deposit.
Great. And was that amount for move-in $1,372.58 in accordance with the ledger?
According to his lease, it was $1,401.52 prorated.
101.52. Okay. Was payment remitted for the month of January? For the
No.
rent? For rent,
Partial payment.
partial payment for rent?
Give me 1 second. Let me pull up his ledger. Sorry.
I don't think I can share my screen here.
No, there was a payment of $647.58, and then the 800.
There was an $800 payment. Okay. So I showed that there was a payment at that time.
Is that one of the 800 dedicated to a security deposit that later was returned NSF?
Yes.
And tell me the dates those payments were received?
The 800 was received on the 10th, and then again another 800 on the 14th.
No, I'm not asking about that one. I'm asking about the first one. Now, when was the 647.58 paid?
The 14th.
Okay, now detail for me. And I'm interrupting, I'm sorry, Ms. Higginbotham.
No, you're
but
fine,
I
Judge.
have a question as the judge and I'm the trier of fact. I need to clarify the issue before you go any further.
Yes, ma'am.
Okay, if his move-in was January 9th, and he's already made statements in his opening statement that could, consider as evidence because I swore him in. He said he originally had a promised move-in date sooner than that date, but eventually is that January 9th is when it actually happened. Okay. And if you didn't get paid until the 14th, this partial payment, what was the partial payment for?
It doesn't show me on the ledger if it was applied to the deposit or applied to the actual rent amount. It just shows me the payment.
When was the concession supposed to start? Were you supposed to get some rent up front?
Yes.
How much was the rent you were supposed to get up front?
It was supposed to be the probation of the 23 days, which is the 14.
Tell me that sum, the 1401.52?
Yes.
That was supposed to be the prorated January rent you were supposed to get.
Yes.
Okay. And then his concession started in February?
Yes.
It was supposed to go for 10 weeks according to the opening statement of the lawyer?
Yes.
Okay. So in your ledger, you have a $647.58 payment made on January 14th. You don't have clear notations of where it was applied to. And then you had a check on January 10th before that partial payment of $800, which, if the security deposit was supposed to be $800, was supposed to be dedicated to the security deposit. Is that correct?
Yeah.
Okay, you may proceed, Ms. Hickabotham.
Thank you, Judge. And Ms. Mendez, do you see that there was an additional payment that was made of $800 for the 14th?
Yes.
Okay. So to go through this for the 14th, you received 3 payments, correct?
Yes.
Okay. One
No,
for
wait a minute. I thought the original 800 was on 110.
Yes, Judge, but 2 of them came back NSF. So the one from the 10th was returned NSF. There was
And he replaced it on the 14th that also was NSF?
Yes.
Okay, so on the 14th, you get another security deposit check of 800.
Right. And then, Judge, we received
Payment. I know a lot of times people don't use checks anymore.
Right.
But they use debit cards, they use PayPal, they use credit cards, whatever.
Right. Yes, ma'am. But it's the ACH, so it runs the same as a check, Judge.
Okay.
And Judge, and to clarify, Judge, that was one payment of $800, one payment of $647.58, and one payment of $800. One of those was returned NSF in the amount of $800.
So at that point, on the 14th, you'd already received a payment on the 10th for
And that was
$800. Did you know by the 14th that it had, because you had split his security deposit, right? You were letting him make it in a couple of payments?
No, ma'am. He needed to pay his
So why
security
was he
deposit.
paying you again something he had paid you on the 10th? Miss Mendez.
Oh, sorry.
Not sure why he made the payment of 800, like just of 800, but once he made the 800 and then additional the 640 something, it cleared out his balance to 0. So his technical rent was zeroed out, like his ledger was zeroed out at that time. And then he made another one.
And that was to cover the security deposit.
In other words, that first payment of 800 possibly was, and more reliably applied to his rental, so it zeroed out his rent and he had a small credit. So,
Yeah.
right? Okay, go ahead, Ms. Higginbotham.
Thank you. Judge, I think we figured out the security deposit. Ms. Mendez, since the issues that occurred from January the 14th with Mr. Hicks, has he remitted payment in any form for April, June, or July?
No.
Okay. Or during the course of this dispute with Mr. Hicks regarding the security deposit, was there an option to allow Mr. Hicks to pay his make his rental obligation in the amount of $925 for the month of April, which he refused to remit payment?
Yeah, we worked with him.
Right. And at the time when he refused to remit payment or failed to remit payment for the month of April, at that time, you all were able to or canceled the concessions and issued a payback on those concessions, correct?
Yeah.
Okay.
Okay, hold on.
Yes, Judge.
I'm just trying to follow the logic of the concessions.
Yes, ma'am.
So the first concession,
Oh my gosh. Judge, he didn't pay rent. His concessions were denied, so they're asking for that money back, which they really aren't asking for that money back, which I've said multiple times by now. I feel bad because I feel like I understand this case more than the judge does. And it's sad that should not be the case. I feel like you guys all understand the case more than the judge does. She wants to nail everything down. We don't need to do that.
apparently he was paying you prorated rent for January.
Right.
So the concession didn't start till February.
Right.
Is that right, Ms. Mendez?
Yeah.
I want you to answer too. So the concession for 2 months was supposed to be February and March,
Mhm.
all right? Well, 10 weeks.
Right.
10 weeks is 2.5 months, right?
Right.
I can't speed her up, but I promise I'll stop interrupting her. Call back. This is so much fun.
So that
Which
would have
is-
taken us to the middle of April?
Right, Judge. So that would have only left his balance for April at 925 plus the other incidentals.
Okay, 10-week concession, all right. So we get past mid-April. When was the second concession of 2 months supposed to start?
Right, Judge. So the second concession was to be $2,000 for the month of May. And that was to cover his monthly rent as well as his additional incidentals that would have
Or
covered
is incidentals or what? Like utilities,
sewer, trash.
trash,
It's a
any other
service fee,
fees that all the
service,
tenants
trash.
have to pay for the
Right.
amenities?
Right. Electric is also included.
Termination, electric, all his utilities, or just electric?
No, it looks like electric, trash, sewer, and then the rent service fee, I believe. Was sewer also included, Ms.
So that
Mendez?
2,000 would have covered the. So the total rent for an entire month is what?
$1,850, Judge.
Okay, there you go. That's supposed to be the normal monthly rental, $1,850. I just wanted to
Right.
clarify that.
Yes, ma'am. And then he also had valet trash in the amount of $30, a rental service fee, which
So a
was
second concession of $2,000 covered 1 more month
right.
and then some incidentals.
Right. Yes, Judge.
All right, keep going.
Thank you. Ms. Mendez, after the May 1st concession, did Mr. Hague remit any payment for the month of June?
No,
Did Mr. Hague remit any payment for the month of July?
no,
To date, do you still have that Mr. Hague owes for the $925 for the month of April, as well as the full month of $1,850 per month for June and July?
yes,
Thank you. Also, Ms. Mendez, due to that, was a notice to vacate issued on or about June the 5th of 2026?
yes, we did hand delivery,
And delivery. Okay, and this was a 30-day notice, correct?
yes,
And this was an option to pay or vacate, correct?
correct.
Okay. And is
How
Mr.
many
Hague
days
still
of the
in
notice to
possession?
vacate again?
Sorry.
What was the date, Ms. Mendez?
June 5th,
June 5th. Okay, thank you.
And this notice to vacate was also sent certified mail, regular mail, and also via email, correct?
yes,
Thank you. To date, is Mr. Hague still in possession of the property? Have you received the keys for the unit?
he's still in possession. I have not received the keys.
Thank you. And have you received any rental payments under that option to pay the rent?
No,
Thank you. Judge, at this time, I will pass the witness.
Okay,
If Mr. Hague has any questions for Ms. Mendez.
I'll explain that to him. Okay, Mr. Hague,
Yes, ma'am.
Um,
Yes, Your Honor.
the direct testimony of the plaintiff's witness, Ms. Mendez, has concluded for right now. So now is your opportunity to cross-examine her. You can ask her anything. And sometimes explain cross-examination a little bit to people, because in your mind, you have this story that includes your facts or how you know something. But you can't start making statements about that, because you'll tell me when you testify. But you can structure some questions during cross-examination for the witness on the stand that take into account your set of facts. So let me give you an example. But Ms. Mendez, isn't it true that, Ms. Mendez, isn't it a fact that on such and such a date I did or said something? In other words, you start to lay a foundation for what you think your facts are going to be by structuring questions about it. But it has to be in the form of a question.
Mhm.
Okay?
Okay.
All right. That's what proper cross-examination is. It doesn't have to be the traditional who, where, why, when, how that elicits a verbal response from the witness, because that's, as judges, that's what we prefer. We don't like leading questions from anyone that's where they just tell them all the facts in the question and they say yes or no. We prefer the words, the facts come out of the mouth of the witness. So at this point, you can start considering whether and how, what is her opinion about the facts as you might know them, you know?
Yes, ma'am.
Okay, go ahead.
First of all, you stated that the notice to vacate was a demand for possession or an opportunity to pay. At the time of the issuance of the notice to vacate, is it true that the notice to vacate also expressed this opportunity to pay in the notice to vacate, Exhibit B of the plaintiff's stuff?
False question?
Sorry.
Okay,
Sorry,
let me ask it a little bit, maybe.
Yeah.
Typically, notices to vacate, Ms. Mendez, classically, should be unconditional. They say just, you haven't paid the rent, you need to move.
Mhm.
Period. Not, or you can pay us by this time, and then if you don't pay by that time, then you go. No, notices to vacate are better in court if they were unconditional when you gave them. That doesn't mean you can't give them a chance, like one last chance to pay, but preferably they should not be conditional. Like you can stay if you pay. It's like you got to go because you didn't pay. You understand that? So he's asking you to describe your notice to vacate and whether it included an opportunity for him to still pay and in what amount. Or were you just giving him a balance? Because that's what was due. Can you just describe that to me?
The notice was notice to pay or vacate.
Okay, so you didn't say, or pay. We're still giving you one more chance to pay?
Yes, notice to pay or to vacate.
Okay, all right, so to pay, did you give a deadline to pay in that notice or not? You can read it to me if you have it in front of you.
Judge, I
Yeah.
have it in our office, actually drafted the notice to vacate. We drafted it.
Okay, you drafted it, okay,
Right,
and
we
you
drafted the
mailed it.
notice. Right, Judge, we mailed it. And the revisions that went into effect under chapter 24 of the Texas Property Code requires that we issue a notice to pay or vacate now, which is why we were.
Okay, all right.
Yeah, that's
okay.
why we were giving him, because I agree with you.
And what amount of time did the notice to vacate, to pay or to vacate give him before he had to actually move?
30 days. So it runs for the length of the notice. So
All right.
if it was a 3-day, it runs for 3 days. If it's 10, it's 10, whatever the notice is. So here it was a 30-day notice. You can pay it or you can leave.
Okay, all right, thank you.
Yes, ma'am.
And you work at the law firm, you're familiar with the file, you're familiar with the letter.
Yes, Judge.
So you are giving me factual information. You are an officer of the court. I
Yes.
don't have to swear you in to take your facts
Yes,
because you're always sworn as a officer of the court to tell the truth.
Yes,
In
ma'am.
case Mr. Hake was wondering why I hadn't sworn you in and I was getting facts from you. That's
Yes,
why, Mr. Hake, okay?
Yes, yes, ma'am.
Lawyers are presumed to be telling me the truth all the time. I don't
Yes,
have to
ma'am.
swear them in.
Yes,
We
ma'am.
do
I'm
swear
totally-
them in for attorney's fees testimony sometimes, but not for things that their office issued, their office drafted, their office mailed, because they're presumed to know all those facts by having access to the file.
Yes, ma'am. I understand. I'm
right.
actually 12 credits away from a pre-law degree, so I understand the processes for that.
All right, and I've been a lawyer for
Yes, ma'am.
47
Oh,
years.
sorry, I
okay?
wasn't. Yes, ma'am. I wasn't trying to. That
Okay.
wasn't my intent. What I was saying. Sorry.
All right, yeah, but I'm glad that you have some
Yeah. Yes, ma'am. Sorry.
some legal background. Thank
Yes,
you.
ma'am. Sorry.
Okay,
about that.
you may
Was not trying to
proceed.
see. Yeah.
So then, fine, let's just continue with your,
Okay.
your questioning of this witness now, your cross-examination of Ms. Mendez.
Yes, ma'am. Previously, is it correct you just stated with your previous testimony that you did attempt to work with me to give an opportunity to resolve the situation?
Yes.
Okay. Is it true that at any point after February 25th of 2026 that you were advised by a third party and or legal advice to not speak with me on any matter regarding the case?
Objection. Relevance, Judge?
Because I was advised by a leasing agent that that was said to them, and she has not spoken to me or attempted to resolve this. So
Okay,
that
okay, so hold on. Your notice to vacate came from a lawyer's office,
Mhm.
but you did have some discussions with Ms. Mendez after you received the notice to vacate from the lawyer's office?
Negative. She has not spoken to me since February 25th of
Okay.
2026.
Typically,
Hmm.
when people engage counsel,
Mhm.
the direct communications between the representatives that are not the lawyers of the client or the client
Yes, ma'am.
end. There's this clear demarcation. When there's a lawyer involved, they cannot have the case compromised by their client having discussions directly with the person who may become the defendant. So I'm not surprised
Yes, ma'am.
if she was instructed she should have no communications with you. So
No,
are you trying to establish that she maybe would have worked with you, but then she couldn't?
Not exactly. My next question.
Okay, well then
should
ask
be
the next
clarified.
question. Ask the next question.
Is it true that I have attempted to communicate with the office regarding unresponsiveness from the attorney's office in my repeated attempts to resolve the situation, which was not received or responded to by the attorney's office, and therefore tried to pursue alternative methods of communicating directly with you and left probably roughly
Okay,
around.
that question's very, very long.
Sorry.
Okay.
Is it true that I did make
It's
that
like it's a run-on question that goes on
Yeah.
forever. You need to
Okay.
break it up, or I'll break it up for you.
Understood. Is it true that I have communicated with the office regarding unresponsiveness from the attorney's office?
Objection, Judge? I have an
No,
objection to
no,
this.
objection overruled. Ms. Mendez, did you ever receive any kind of notification, even though you had some restrictions on your ability to respond, that complained of the non-responsiveness of your lawyer to this defendant or tenant at that point?
All his communication we've responded to. The lawyers have responded to, and we've been CC'd on it.
No, the question was, did you receive, whether you were able to respond to it or not, something from this tenant telling you, I can't get your lawyers to respond to me? Did you ever get a complaint from him that your attorney's office was being unresponsive to him? Did you ever get anything that advised you about that from this tenant who's now a defendant?
I believe there was an email sent regarding that.
Okay. So do you recall the date of that?
No, but I can
Because the lawyers didn't get involved until they sent this notice to vacate in June.
No, Judge, we were involved prior to that. So
Okay,
we
so you've
became
been
involved in March.
before the notice of
Right.
vacate.
So that's what my objection was based off of, Judge. She's asking her about something she would not necessarily have knowledge of, and we would have knowledge of it in the office. So the question would be better posed for me than for Ms. Mendez regarding communication.
Your
that he
Honor,
was trying to get to
it,
us.
it,
Well, no, the question
It's
to her
not-
was, did she ever receive any notification that the lawyer's office was not responding to him? And she said, yes, that she did. Go ahead, Mr. Hague.
Wait, and I have an
Um,
objection to his.
you mentioned that
Ms. Mendez, do you have something else you want to elaborate on your prior response?
Yes, he said that I never talked to him after February, don't know what date, but I have emails and notes of him coming into the office on April 17. And I reached out to a lawyer, letting them know that he came into the office to speak to me regarding the situation. So I did communicate with him as well, even though he's saying that I didn't.
Okay, so it was from an office visit by him on April 17th that you told your lawyers had occurred.
Yeah,
Not
no,
like you can keep a tenant from walking in the office and having a discussion with you, right?
yeah, he still comes in and he still tries to communicate with us, and I still communicate. I'm not gonna shoo him away or anything like that.
Well, I know that that's a good practice as a property manager or assistant manager. And I know it's really hard to draw the line when you have a lawyer already telling you have to limit your communications with someone who's either a potential defendant or is a defendant. So, okay, so there's been occasions when he has come to the office and actually spoken with you.
Yeah.
Okay, go ahead, Mr. Hague.
Yes, it's kind of a follow-up, similar question. Is it true that you have received messages from Mays and/or other leasing agents regarding my communications to attempt to resolve the situation? Mays is one of the leasing agents, Your Honor, just so I could clarify that.
Objection asked and answered, Judge. She said that they have attempted to communicate and work this out with Mr. Hague. I don't think that's
Yeah.
going to change.
Okay, hold on. I don't know who Mays is.
Mays
Is there a
is one of the
leasing agent in the middle between the actual property management on site?
We have
Yes,
a
sir.
leasing.
I'm
we have
asking, not Mr. Hague, I'm asking Ms. Mendez.
Okay, my bad.
We have leasing staff, we have 2 leasing agents, and then myself.
But you're all on site?
Yeah, we're all on site.
Okay, and what does the word maze mean?
Oh my gosh, Judge, it's a name. This is so painful. It's so painful. It's someone's name, Judge. German juror. I was a young man when this case began. Yeah, we all were. We all were. I told you it would be hilarious and frustrating all at the same time. And I think I've lived up to that. Uncle Dan, thank you so much for the super chat. Heck, German juror. I was a young man when this comment by the judge began. Thank you, Uncle Dan. I appreciate it. And Bill, Colin's just playing this case to get back at the mods and chat for all the crap we've given him. No, I'm not. No, I'm not. What crap have you given me? None. You guys are awesome. Thank you so much. Thank you so much for hanging out. This case is fun though. I told you we'd have that kind of night tonight. Anyways, let's go.
That's his name.
Are they on site, but they're a separate entity?
No.
Mays is
No?
a single person.
Yeah.
Oh, that's
Yeah,
the
his real
name
name
of
is
the
MP Show.
person. Okay. And Miss Mendez, who is this Mays? Is that one of the 2 leasing agents?
Yes.
Is that his first name or his last name?
That's his middle
Is
name.
it a Miss or a Mr. or what?
Mr.
Mr. Mays, okay, but he's not a separate entity. He's a leasing agent that works for the company.
Yes.
Okay, because there's different, organizational charts, manager, assistant manager, leasing agents, maintenance. So he works for the company. And
Yeah.
his name is Mr. Mays, but he's not a separate entity.
He still works for Richmond.
And he still works.
Yeah.
And this management company, is it a separate entity than the owner, or you work for the owners that are listed on this petition?
I work for the owners. It's not it's owned and managed by Same.
Okay, TRG TCHFC Austin Gateway Mixed Income LLC is your boss.
Yeah.
Okay, all right, go ahead, Mr. Hague.
Can I step away, grab my charger real quick? My phone or my
Sure.
computer. All right.
Remember, I'm doing some reasonable accommodation, although I'm not sure that I'm required to. So I'm giving him time to move, get his laptop. I don't know what he's about to do.
Okay. Yeah, I need to plug in my MacBook.
Okay,
Your
all
Honor.
right, that's fine.
Sorry. So I don't know if the question was answered, but is it true that you did receive messages from one of those leasing agents regarding additional attempts to resolve?
Do you have a specific time frame?
I've made at least 20 attempts, because I've made 4 per week for 2 of the weeks, and an additional 2 per week.
Okay, okay, hold on. You sound like you're testifying now.
Sorry.
It sounds like she asked you a question, like a time frame. What you need to do is you need to put it in the form of a question.
Okay.
Are you aware that on these occasions or on these dates that I was attempting to communicate with the company? And tell me through who? You know,
Okay.
because apparently you're saying you've made a large number of attempts to.
Who would think it'd be hilarious for her and Judge Rossi to be in a conversation with each other? I personally would. It'd be a simple question like, hey, I haven't been outside yet today. Is it sunny or is it raining? 45 minutes later, we would know nothing.
Mediate, discuss, talk about possibly settling this. And now you're indicating based on your statement, and you're not the witness right now. That's why I swore you in a long time ago.
Yes, ma'am.
That you've made, to your count, 20, at least 20 attempts to resolve this thing. So is that your question to her? Is she aware of the occasions when you've tried to communicate about a resolution?
Yes, Your Honor. That is my question.
Now, I'm asking you because she
sorry.
asked you, but
Yeah.
you're not supposed to. I'm asking
Sure.
you, what's the
Understood.
time frame of these alleged communications to attempt resolution, Mr. Hague?
Yes, Your Honor. It is a large time frame. It was between March 23rd. I might be a day or two off, but March 23rd of 2026 through June 22nd, 2026.
All right, so recognizing since some attempts at communication may have been closer together, on average, if it's 20 or thereabouts, between March 23rd and June 22nd, which is 3 months. On average, it would be like 7 attempts a month to communicate with him.
Yes, yes, Your Honor. And Ms. Mendez, were you aware of those repeated attempts to communicate regarding resolution?
Not all 20, if I'm gonna be honest.
Okay.
Okay, now hold on. I'm just looking at my notes and the timeline of how these concessions happened, when they were supposed to start, when they were supposed to end. In March, there doesn't appear to be any rent dispute because whatever you paid up front in January took care of whatever prorated rent you had in January. So
there was.
Concession went to mid-April, so any attempts to communicate with them in March and April would have involved that security deposit, not the rent. You had a concession.
Right.
Or were they already threatening to
Remove my
revoke your concession? Is that what?
Oh, I think Mary Mendez is the only person in this hearing right now that's like, why is this going on this long? I've got work to do. The attorney's being paid by the hour. She doesn't care. The defendant, I mean, he can't pay his rent, so he obviously doesn't care what's going on. The judge is pro tem, and I think she's trying to prolong this as long as possible. She's the only one that wants to get back to work. Come on, everybody. Come on. Like, can we wrap this up? It's a very simple case.
What
Yes,
happened?
They
Okay, that's what
revoked
I
it on
wanted
the
to know. I wanted
24th.
to follow through what's happening here.
Yes, ma'am. Yes, Your Honor.
Okay. Go ahead.
Is it true that those and I might be saying this wrong, contractually promised concessions were removed on or about the 24th or 25th of March?
The system automatically will remove them if you don't make payments. So I don't exactly know when.
Well, you need to know, Ms. Mendez, look at your ledger. You figured it out right now. When did your system attempt to revoke the concession? Because the concession started in February. Figure it out.
To help here, and
You
I
should have
believe
been ready. You should have been anticipating this concession being involved in this case and its revocation for non-payment.
Judge, I have this in front of me. What I see is not March, but April 23rd. It's not March, it's April. And this was after he failed to remit payment.
So then you're helping me because you're looking at a ledger, Ms. Higginbotham?
Yes,
And the
Yes.
first attempt by the system to automatically revoke a concession, it didn't happen till April?
right, Judge. And the reason
Oh my God, Judge, they're not even looking for collection on the concessions. They've already stated that on the record multiple times. They're not looking for that. They want the dude to move, and they're asking for the rent without the concessions. Why are we spending so long on this? We're only about halfway through this case, guys.
it happened in
And
April,
apparently, because half of April rent was due
right?
in
And
mid-April.
that's why, right?
Okay,
That's
all right.
exactly why, Judge.
All right, okay, thank you. All right, keep it moving, Mr. Hague.
Okay.
Keep it moving, Mr. Hague. Okay, Judge. Yep, we're going to keep it moving.
Sorry, give me one moment.
That's all right. Just gather your thoughts. They're paying me here till 5:30 actually.
Oh, we got a still frame of her nose for a second. We should go back to those and
Is
freeze
it-
frame it, see what we get
I
there.
guess that might be this might be a question for the attorney, so I don't know how this one would be. But is it true that in previous statements made to the court,
I can't on StreamYard. I can't speed it up on this end. I can on YouTube when I'm recording, but I can't do it now. Sorry, not recording. I don't record court. I get it from third parties or I find other ways to get it. Yeah, I can't speed it up on StreamYard. I'm sorry.
that there was two different amounts claimed that were owed of different rent payments, including prorated rent that were claimed. Oh, sorry, let me reword that.
Okay, it's very clear to me, Mr. Hague, so I'll just like orient you
Yeah.
to what is in my head already.
Yes, ma'am.
There was no allegation that you were behind on the rent, the prorated rent you were supposed to pay in January, which may have caused an issue with the security deposit, right? Because they took the $647.58 and $800 together that more than took care of what your prorated rent was for that month. So your rent balance came down to zero. And then I don't know how many times you made the security deposit payment of 800 because of alleged on NSF, but issues with your rent didn't start because of the lengthy concession until mid-April.
The prorated rent was actually the part that was being disputed. Until today, I didn't know that they weren't trying to claim for the prorated rent or the security deposit. This is the first time I've heard of it, because every other documentation I've been provided has mentioned that security deposit and prorated rent amount in these filings.
Okay. Well,
Judge Emerson.
that's because they haven't pled for that and they're not looking for that now. But yes, there's a possibility when they were making demands before filing this case, and Ms. Higginbotham can correct me if I'm wrong. If they misapplied your security deposit to what would have been a portion of the prorated rent in January, and then you didn't have a security deposit at all paid either, there may have been at the initial stages of this some allegations of unpaid rent for January outstanding. Yes, I realize that. But at this point, they're not going that far back and they're just going forward. Okay. But yes, it's apparent to me. And they had a prior eviction that they dismissed. So that prior eviction had to include that. It had to. I know that. I understand that. I've been doing evictions for over 30 years. Okay. I know that. I understand that. Okay. So yes, and obviously whatever issues happened with the security deposit did cause a cascading problem. It's apparent to me that could happen. So if you never resolve this deposit thing, which they're not looking for today because they can't get security deposits in this kind of a lawsuit. But yes, and Ms. Higginbotham, I hope you heard me. Understand why at the inception of the dispute between the parties, it could have involved some quote, unpaid rent for January because you all thought it had been full paid, and then that $800 bounced or whatever. So then there was issues with the rent in January. Yes. And then yes, if that wasn't resolved and resolved quickly, that would have caused a withdrawal or a revocation of the concession.
Right.
So yes, it's a compounding thing. And I want you to understand, Mr. Hague, that I understand what's going on here. I have a good head for landlord ledgers. I've been doing this long enough, and I have a good head for numbers. I used to be a lawyer for IRS, okay?
Damn. Sorry.
All right, we'll keep going.
Yes, Your Honor. Ms. Mendez, is it true that you or counsel have received, is it true that you have received notification of an intent and willingness to provide the disputed amounts of payments that are alleged to be unpaid?
For the house?
No, in specifically the April and June periods.
Yes, you filed a lot of stuff.
Yes, you did. Okay. With that being said, is it true that no communication was provided to me that you were not interested in giving me an opportunity to cure with the payments that I was willing to pay?
No.
Okay.
Okay. Ms. Mendez, was there ever, and obviously Ms. Higginbotham, if it's something that she can't answer, you can comment instead. Especially when a notice to pay or to vacate has been issued, it's apparent to me as a judge that kind of incorporates like an opportunity to cure in there. Like, this is what you owe, this is how long you have to pay it, and if you don't, then you got to move.
Yes, he
Yes.
was not willing to pay,
The full,
his
that's the
amount.
problem here. He didn't want to
Yeah.
pay the full.
Okay,
Um,
that's what I hear him asking. If he was ever given an opportunity to cure. So can one of you, the
Can I-
second Boston,
can I
because,
clarify the
wait, no,
question?
no, you wait.
Okay.
Because the notice to vacate, to pay or to vacate came from your office.
Right, Judge?
What
So-
was that opportunity to cure that was offered, please? He's asking
The-
about an opportunity to cure. What amount did you tell him? What deadline did you give him?
Judge, in the notice to vacate that's attached to the petition, it was sent on June the 5th. It gave him 30 days, so it was until July the 5th, I believe, to remit payment for the full amount, including the concession payback. So that amount would have been, hold on, Judge, let me give you the amount here. I'm so sorry. I believe it was,
Okay, at that point, that demand,
it included the
drew
concession.
in the revocation of the concessions
Right.
pursuant to the addendum. Okay, go ahead.
Right, so it was $10,050 is what was owed as of June the 5th, because as Ms. Mendez testified earlier, around April the 23rd, the system went in, it removed the concession because the rent was not received for April. And Judge, also just a comment, the communications that we have from Mr. Hake were multiple requests for reasonable accommodations, and in the majority or the bulk of that, it was no mention of him remitting payment for his monthly rental obligations.
Mhm.
And unless I'm missing something, and that's a possibility, Judge, we have hundreds and hundreds and hundreds of pages of emails from Mr. Hake. So I could be missing something here, Judge, but that option was afforded to him to forget about the security deposit, remit your payment for the month of April, and he did not do so.
Your Honor, may I make a note real quick? It was on call with the head attorney that's listed on this case, Brianna Lands. It was on a recorded call. I was having trouble figuring out transferring the file type, so I wasn't able to send that in, but I could send that in pretty quickly. I have a recording from that call where
Was she aware she was being recorded?
she was not, but due to two-party
Okay,
consent.
no,
it
I'm
fixes.
not gonna take anything. If she wasn't aware she was being recorded, it was without her permission.
It's two-party
And then
one-party consent.
I'm sure Ms. Higginbotham would raise this if you tried to have it admitted. It was during any settlement
It's one party
discussions you may have been having with her.
It was
And
settlement.
those are prohibited from coming in
Right.
as evidence during the case. Any conversations involving attempts to settle cannot be brought into a courtroom. The rules of evidence, I can't get an objection on that basis, and I can't, it requires me to not allow the evidence in, so.
Oh,
And
okay.
Judge, just piggybacking off of that a little bit, because
I mean, what? Oh, you recorded a phone call and you want to bring in evidence. Yeah, all right, man. You're not winning this, by the way. He's not. No one's winning this case. The landlord is not winning this case. The attorney, the judge. I think the judge is the only one winning this. She's the one happy about what's going on. MB, thank you so much for the super chat. I appreciate it. Classic stream already. Oh, it's so good. It's so good. It's so bad. It's so good. And this explains it perfectly. Pamela, thank you so much. My hair is getting grayer and grayer by the minute. Yeah, it is. So is mine. So is everyone else's, though. We're all in the same boat. But you know what? I made the decision to play the rest of this case. I was going to make this a 2-night thing. We're not. We're going to finish this tonight. We're at the hour and 20-minute mark. Hold on. I'll tell you exactly how long the video is. Hour and 20 minutes out of 2 hours and 3. We got 40 minutes left. We got this. We can do it. Let's go.
this is JP Court, I am allowing Mr. Haight to pose these questions regarding his attempts to settle the case, even though we know that's not really within the scope of what we should be discussing here, I believe. We do agree, and I think Ms. Mendez's testimony states, yes, you've reached out to us on trying to settle the claim. So I don't think that that's something that's disputed. There are some other nuanced things with that, I'm sure, but if we want to proceed on the line
So
of
it was
questioning.
apparent that this opportunity to cure wasn't giving him an option to pay what you're seeking in terms of a judgment here today.
Right, Judge.
Today, you don't want to mess up what you're asking for in terms of.
This is the comment of the night. Thank you so much for that. This is absolutely the comment of the evening. He'll another month when it ends. He will. He will. I mean, he's close. He only has to go for 48 more hours, and he's got it.
A monetary recovery. So you've basically left out the concession months.
Right.
Not that you've totally waived them for all purposes considered, but you're not asking for that here.
That's correct. Correct,
In the
Judge.
opportunity to cure,
Mhm.
you were that there was no concession involved anymore, and you were looking for full rent from the day he moved in.
Right, Judge, because if he were to stay, he has to clear his balance, right? And the balance is what it is. Even if we seek it or not, the balance is what it is.
Well,
property-
yeah, I understand
Yeah,
that,
it's just
but sometimes people, when they're trying to not understanding the legal effect of the
Right.
addendum on their concession,
mhm.
it's very clear. I don't know if you had a chance to go read your addendum, Mr. Haig. I've read a ton of them because there was a time frame when I was the judge of this particular court where concessions were very common.
Yes, Your Honor.
And then I had to do decisions that revoked the concessions and made people and enter judgments that included amounts of money they thought that they didn't owe because they didn't bother to have read and absorbed and understood that the minute they didn't pay something, they would lose the concessions to the inception of the lease. So
Your Honor, I was willing
I
to
don't
pay
know
the
what to tell you
10,000.
about that, but other than that, you're asking, were you given an opportunity to cure? It sounds like your opportunity to cure included concessions that you probably
No, I was willing
objected
to
to
pay.
have been revoked or discontinued or whatever language you want to put on that.
Negative, Your Honor. I actually was willing to pay those just to get this done and over with because I was, like I said, I was out of state. I'm currently out of state and I just wanted to get this over with. So on June, sorry, I'm looking at my calendar, so give me one moment. I don't remember if it was the 12th or the 5th. It was the 12th. On June 12th, I advised the office that I was willing to make the payment. I only asked that with that, I even
What
added in,
office? The lawyer's office?
no, the
Okay, but at that point, you had received a demand and a notice to pay or to vacate with a deadline to do so from a lawyer's office. Why weren't you talking to them? Why were you
because
still
they were not
talking to the
responding.
office if you had already been told you should not be communicating with the office?
I made 4 calls to the office and they were not responding. And this is another thing. I communicate primarily verbally. I struggle with written forms of communication. If you look at my things, they're all AI formatted because that's my only way of communicating. So I attempted to call the office numerous times, and the
Well, I'm
front
like
desk,
you. I would rather talk to somebody in person than
they're
having to
in
be
Houston.
sending them emails.
They're in
Just
Houston.
it really like I had a dispute with a company about something I ordered online and I got double charged because of some error on my part when they sent me a email saying, "Oh, well, you go back to the cart because you didn't finish," and blah blah blah.
Your
And I
Honor, they were in
believed them.
Houston.
And then I couldn't get anyone to answer a phone or to talk to me in person, and I wasn't getting any response to any of these email chats with these people. So I'm just disputing the second charge on my credit card, and we'll go from there. But I understand.
I understand too. Best judge ever. We need Judge Diaz. We need more of Judge Diaz. Oh, how awesome would it be to see her in a sovereign citizen? Let's go.
Your Honor, they were in Houston.
I prefer to talk to people.
Yeah, they're in Houston, Your Honor, and it's due to my autism and ADHD that I cannot properly communicate in written communications without the AI, and even that AI isn't trained. very well. It's not the best. So I was trying to communicate verbally. They're in Houston. I don't drive because of my autism and PTSD, so I have no way to get to Houston from Austin. I mean, that's how do you get from if I don't drive? So that is where I did go down to the office, the leasing office, to try to make the communications through them because that was my only
Okay,
reasonable path.
I get it. I get
Can I
it.
ask a question? Was he in town? I'm lost a little bit here as to whether
I
he
left
went
on
in.
No,
June
he
23rd.
he's not. The reason we're having this virtually, even though we have virtual
Oh,
dockets for lawyers anyway, is that he wasn't here.
right. No, Judge, I was asking at the time because he's saying that
Oh.
he went in and tried to remit payment for the $10,000, and I'm wondering when our last
Okay,
email
that's a
communication
good
I left on
question.
June 23rd. I left on June 23rd of 2026. I had made these attempts before I left. I flew out on a Southwest flight to Seattle, Washington on the 23rd and arrived on the 24th. And
So
I've been here.
That makes sense. This seems like someone that Dan would defend. Dan, have you ever defended this guy? I feel like this is one of your clients. But yeah, can you imagine? Oh, so you don't think I have jurisdiction? Well, I remember one time that I didn't think I had jurisdiction. Back in the 1970s, it was a crazy time. You know, the rain was coming down. I didn't think the court had jurisdiction over me, but I still showed up because I was worried about the jurisdiction. And then when I showed up, I didn't have my nail clippers, and I couldn't clip my nails while I was waiting for my case to be called, and it was very bothersome. Yeah, I feel like that's what the story would be.
So
Same.
between the receipt of a notice to
On
pay
the
or
5th.
vacate that was sent on June 5th, you attempted before leaving on June 23rd. So there was like a 2-week time frame there.
Yes,
So you
Your
were
Honor.
trying to pay the amount stated in the notice, right? The
Yes, Your Honor.
10,500?
Yes, Your Honor. And the next question I have for Ms. Mendez will actually
Judge,
expand on
before
that a little bit further.
before he commences with that, I would like to be able to confirm if that occurred with Ms. Mendez as she was in the office. If
Okay,
she-
yeah, that's good. Can you
Yes,
This
confirm?
was through the leasing agent. I can
No.
confirm that for you. This was through the leasing agent, and they left a message for her that I saw them write the message. It was done
Okay,
once. It was done by
which
me.
leasing agent? There's two.
Infant Jones did it 2 of the times, and the 3rd time was done by the lady. I don't remember her name, but it's the other leasing agent.
Well, there's
Okay.
only two leasing agents and one
Yeah.
is named Mr. Mays. Who is the
Yes.
second one?
I don't remember her name. I think it starts with a J. I don't.
What's the name of your second leasing agent, Ms. Mendez?
My other one is Allison.
Allison, that's what it was. Sorry.
Okay.
Did not start with
So
a
you
J.
were communicating with an Allison?
Yes, it was the other lady there,
Okay.
and the shorter lady.
Let me ask this, okay? I'm just proposing something that'll give us some time to work on this.
Mhm.
It sounds like, Mr. Hague, you wanted to resolve this and pay this amount in full. You're still gone, you're still not in town.
I come back on the 7th or 8th of August.
On August the 4th, I'm here
Yes, Your
in
Honor.
the court. And
Okay.
I'm here basically to do
Okay.
sign documents for the judge. There's a lot of dockets that have a lot of paperwork that comes in that I help move.
Okay.
Like-
Understood.
Motions for receivership on credit card cases with judgments, on default judgments on credit card cases.
Is it about time? Is the judge drunk? Are we allowed to say that? Can I say, like, Judge, I'm gonna need you to breathe into this. Is that okay, or is that crossing a line?
Just a ton of stuff. Lots
Yes.
of motions to dismiss that come in regularly, that pile up, that need a judge's signature. They can't be processed till the judge signs them. On occasion, I come in just for that. Okay. That doesn't mean I can't get virtually online and
Mhm.
finish a case I started today.
Yes,
Judge,
Your Honor.
So listen
Before
to me.
you proceed, can I make one comment, Judge?
Sure. Yes.
I have a problem with the muddying of the water here by saying he attempted to make the payment or remit payment when my last
He was
email
offering
communication.
it. He was offering
Right,
it.
no, but this is why I say that I have a problem with it. I received an email from Mr. Hake on 6/22 saying that he attempted to resolve this issue and voluntarily vacate the premises if we could reach a reasonable agreement. Nowhere in this email to me has he mentioned, inferred, brought up that he's tried to remit payment, nor did he make an offer to remit payment at that time. He never brought this up. So
But he was communicating with you
with
or
me,
your law firm,
right,
yeah.
on the 22nd. So if
A
he
day before he left town.
exactly.
Yeah.
So if he attempted to remit the payment, then why was it not included in the email on the 22nd? Or he attempted to reach out to us to ensure that we could accept payment from him. Judge, I assure you, if he would have offered us $10,050 to cure the bank, we would have taken it. We wouldn't be here. It doesn't make sense.
Because I was gonna.
I absolutely love that Miss Mendez I think Miss Mendez is the person in the chat right now. She's like, what is going on? Her eyes are saying everything that we're all thinking. She's like, this is bizarre. This entire hearing is bizarre, and I just want out of it.
I just some background that way because it might be slightly relevant. Sorry, trying to figure out how to word it. I had made the attempts to remit it via phone call. I called your guys' office multiple times. I was sent to a voicemail for Brianna Land because that's who I primarily contacted to because she's been the one listed as lead attorney on this case for the entire duration. Miss Brianna Lands is the one that I have primarily communicated with, unless I remembered to CC you, and which I didn't remember all times, to be honest. And that's understood because you weren't listed as the lead attorney, so I was communicating primarily with Lands. When I called, I requested Miss Lands multiple times, and I did go in person. Like I said, 2 messages were left with Maze, 1 with Allison is her name then. I just knew it was the shorter lady that worked there. She's been there since I
confirmed that you said you were not going to pay.
Right. And our email, Judge, with Mr. Hague says that he wanted money from us for him to move. He
Yes,
never
because
made
I
an
had
offer
given.
to pay. And
What
also
were you asking money for?
So as of the 22nd, so when I had originally offered to pay, that was roughly mid. It was about a week after the notice to vacate was done. I had asked them and advised them that in order to move out before I left, that I would need a response by the 19th of June. This was advised because it's impossible to get another place to put my stuff a day before we leave, obviously. I mean, where am I going to put it? If I'm leaving the next day, where am I going to move all my stuff in one day? So I had requested, reasonably so, decent enough in advance, that they give me a response whether I can and how I can by the 19th, which I believe is a Friday. So, because that gave me at least roughly about 3 to 4 days, because I left at the nighttime of the 23rd. So that gave me about 3.5 days to move out, which is reasonable. I have been in contact with numerous locators. I had
No,
a
I'm
couple.
asking about this demand that they pay you.
Yes. Yes. So that was made afterwards.
Why
after
were you asking for money when you were proposing to pay 10,000?
Because afterwards I had talked to an attorney, and they advised me that I shouldn't have had to pay it because of the situation on hand. That I'm not going to try to quote exactly what he said because I don't remember exact wording, but he had advised me to try.
Because you didn't talk to an attorney. You talked to one of the legal scholars on YouTube. You know, like me. You know what I would have told you? Hire an attorney or pay them the rent. One of the two.
To attempt to settle with that method and offering the way to move out because of the fact that there was so many inconsistencies. He felt that an eviction proceeding would be I don't remember the exact word, but he said it was like improper or something like that. And excuse me if I'm not using the exact wording that said attorney used, and that is completely on me. I understand that might not be. Yeah.
Sure. If I can respond here really quickly, the first attempt to settle, I believe that's relevant here, was on June the 3rd. This was even prior to our notice to pay or vacate being issued, where Mr. Hague reached out to us and said that he was willing.
Dan, it's not hearsay. I talked to somebody who talked to their mailman who had an uncle who was once the assistant chief of, of a police officer one time, and he told me this one thing. That's not hearsay. That's direct evidence, Dan. Okay? Stop it.
To discuss a relocation assistance or cash for keys for him to
I was about
voluntarily
to use
vacate
that
the
term. It's typically used in a foreclosure setting, but
Right,
sometimes
Judge.
I've seen
That's
some.
what he included in the email. Right. Those
Wow.
were his words included in the email. Shortly after that, Judge, we received the demand for payment of $2,500 for him to vacate the unit. Nowhere in there did he make any sort of reference to remitting payment. None of that was mentioned. Based on what Ms. Mendez has said, her representatives are there. They've confirmed that no attempts to pay have been made. So Judge, resetting this another week is only going to
No,
exacerbate.
that's fine. I
Yeah,
understand. Is he
okay.
gone?
Yeah, he's gone, Judge. I'm not
Okay,
sure what's
let's
happening.
just
I'll
wait
hold.
till-
We'll wait.
Let's give him some time to get back on.
Okay.
Don't talk anymore. We'll just wait.
Yes, ma'am.
But I hear what you're saying. I was gonna ask him if he's offering to pay again everything that you say is due.
Oh man, this is the best comment. We got words are hard. We were topped up. My blind dog is now wishing she were deaf. Yeah. Yeah. I don't even remember what the last best comment was, but you win. You win.
To be able to stay.
Right.
But I don't know. I don't think that that's really what he's gonna offer or thinking of offering.
Right. But Judge, they have spent so much in just legal fees with this. They can't.
No, that's fine.
Yeah,
No, I'm good. Let's
Yeah.
just wait till he's back.
Okay.
He's calling the court, so we'll have him transfer in.
Yes, please. Unless he can get back on Zoom.
Maybe his computer died.
I don't know.
All those times where the judge can give these stories, now is the proper time while you're waiting for someone to come back. Not on the record. Just saying. Again, I want Judge Diaz and Judge Rossi to be in the same room just once. Just once. I don't want to be there. Let me make that perfectly clear. I do not want to be in that room, but I would love to, have it happen.
Okay, my internet's back. You can, I think your clerk would just came over to you, so I'm gonna hang up on them.
Okay. I'm gonna ask one question. Because we need to finish with this witness.
Okay.
Because really this has turned into your testimony anyway.
Oh, I see.
You're already sworn. I need to,
Mhm.
because they need to rest.
Yes, Your Honor. I rest with
Is
this.
it your intention to offer full payment to them now or not?
Mhm. At this time, yes, Your Honor.
How much?
I can offer
Obviously, we have another month that's gone by that's not included in the original sum they told you was owed.
Mhm.
July is come and gone. That's another $1,800 and what, $50?
Yes. If I'm in, I'm asking Adriana, is the 4,400 or whatever, is that including July?
That's
Just
including
to-
July, but that's the amount we're seeking on the judgment. If you want to clear your balance, you're
I'll cover
gonna have to
August.
clear. How much?
Now, remember, hold on, let me explain that to him. Right now, to have a clean case, they're not seeking those months as a judgment from the court
Mhm.
for, that would have been the concession months, which was a lot of money.
Right.
Understood.
They're trying to keep it clean
Yes, Your Honor.
because they're interested in getting possession primarily.
Okay.
But that doesn't mean that they're waiving that because they do have an addendum to the contract that could sue you later, okay?
Yes, Your Honor.
Oh my God, Judge, stop. Stop on the concessions. We all understand.
Honor.
That's what they're asking for from the court.
Okay.
I'm
Yeah.
asking you, what is it that you are willing to pay? If a month ago you were willing to pay $10,050 to finish this before you left town, and we've had another month of rent come due and outstanding. So if they were originally in a notice to vacate that they sent you in June demanding $10,050, and it took into account this 30-day period that they were giving you to pay or leave.
Okay.
Now we're adding another month of rent, which is July. Is that right, Ms. Hickenbotham?
Yes,
That's
Judge, and then
another
April.
$1,850.
Yeah,
Okay, so that means that we're looking at 11,900. Because I'm
12,300.
going to proceed to a judgment today, and then all the appeal deadlines and everything are going to kick in. Unless you tell me you're offering them 11,900 and that you'll pay by a certain day.
Can I check
if you don't pay by a certain day, we'll be back here on August the 4th when I'm working in this court as a visiting judge to finish and for me to sign a judgment.
Yes, Your Honor. Can you give me one moment? I'm gonna check my bank account real quick.
All right.
And Judge, there's also utilities and other things.
Oh, yes, I realize that.
yeah.
So, but you didn't make a demand for any of that in the original demand?
No, Judge, because we can't.
Okay, all right. And excuse me for assuming that I could give him a sum. Contractually, you also must owe a bunch of other stuff at this premise.
Let me check my bank account real quick. I know I'm way behind in rent, but I think I might have this 12,000 in my bank. All right, man. Like I want to like this guy though. The balls of him to show up to court and argue these things, but at the same time,
which is
prolong this entire hearing this long with the help of the judge and the defense attorney. Again, while Miss Mendez is like, I've got lunch plans today, guys. Yeah, it's 3 p.m. I had lunch plans 3 hours ago. I I'm having a lot of fun. I hope you guys are too.
Sounds like a very luxurious premise if the rent is $1,850 a month. You have other things that
yes, Your Honor.
And you may owe all those monies now that you haven't paid all those months you weren't paying rent, period. Utilities, extermination, trash, whatever. I don't know what on average, or do you have a total that includes all the balance that's due and outstanding at this unit, taking into considering the loss of the concessions, Ms. Higginbotham? Do you have a total sum?
Electric was canceled in June. Internet's been out since April.
Oh, so you have basically vacated these premises by canceling your utilities?
No, I didn't cancel it willingly. To be honest.
Oh, because you're gone and they were disconnected for non-payment of rent.
Yes. Well, the June one I hadn't.
Well, I don't know that that things are disconnected for non-payment of rent when it's being provided by the landlord.
Yeah, PUD shut off my internet on June 28th. That might not be the correct. It's one of the days.
How do you know if you're not there?
Emails.
Okay.
I get emails from the PUD district or whatever.
Okay, well, that's a minimal cost email for 1 month. What, $70?
Yeah. So
Judge, let me see. Ms. Mendez, can you give us the amount that's owed right now? Do you have the ledger right there?
Yes.
That includes everything, Ms. Mendez.
And it includes already next month's rent.
Yes, including the July, not August, but yes, we'll talk about August in a minute because a proposed payment date is going to go into August.
Right.
Or the proposed date could be July 31st, is Friday.
Yeah. 12,549.67.
How much?
12,549.67.
That does not include August.
That does not include August.
Okay. All right, there you go. With all your other amounts due and knowing that can never be the subject of an eviction case because they can only sue for rent.
Of course.
The
Let-
amount
let-
on your ledger is 12,549.67.
Understood. Let me go ahead and check my bank
All
account.
right.
I have that. Okay, so I've got invoices.
And keep in mind,
Yeah, let me
Mr.
pull up
Haig,
calculator.
you have had possession of these premises for a very lengthy amount of time
Mhm.
and made minimal payments.
Understood.
And Judge,
Yeah.
I'm not sure.
You moved in January.
Yes, ma'am.
I mean, yes, I know the draw for you was those concession months, but if you didn't comply, you lost those concessions contractually, and a court would make that finding. And that lawsuit, I'm sure, will follow if you don't pay it now.
Of course. And the reason for that is because I had to resign from my job due to medical reasons. So
Okay.
but that's irrelevant to the score, I'm sure.
Judge, if I may, if he can't pay it, then that's fine also. If he needs, I think we can push out the writ date some to allow him to come back and get his stuff.
Yeah,
But we
that's
do need to get judgment so we can get this unit. Because Judge, also, this is a mixed income property. So we have to do things by the book here. We don't need TDHCA or HUD or anybody coming in doing audits. We'll have problems, large issues that could affect the community at large, right? So it's just, I understand Mr.
I just want
Hayes.
to tell him,
Yeah.
understand that we could, let me explain to him, Mr. Haig, when a judgment is rendered in a case and it's not appealed within the appeal period of 5 days, they can immediately, because the judgment's finality with non-appeal, can get a writ of possession and be trying to get you and all your remaining possessions taken out of the premises.
Yes, sir.
Basically, within 2 or 3 days after the judgment becomes final without appeal.
Mhm.
But they have up to 90 days
Mhm.
with extensions that could be granted by the court to actually seek a writ of possession that would be executed by the constable's office. They still have to take acts to get their writ of possession, to actually give them permission to take all your possessions out of it. And they don't have to store it for you. They put it on the street. And
Understood.
I can tell you, there'll be a free-for-all with all the neighbors coming to grab whatever they can, understanding that that's
Dramatic situation. Yeah.
Yeah.
so. From the inception of your lease in January, and that's because I multiplied 8 months, January, February, March, April, May, June, July, and then August. Well, let's just go through July. That's 7 months worth of 1850 is $12,950. I know that January was a little bit smaller because it was prorated. But this 12,549.67 sounds like a pretty dead on of what's due and outstanding. When it includes all these other utilities and stuff that you may also have not been paying. You have been in possession of premises for a 7-month period, and you made a minimal payment. Okay, so I'm not inclined to keep this dragging on much further unless I get a commitment from you that you're going to pay that balance and you're going to pay it by a date agreed to by the parties, or a judgment will issue. And I have the capacity to issue a judgment next Tuesday on August the 4th.
Yes,
Because
Your
I
Honor.
will be here and I will be contracted and I have the ability to sign it that day.
Yes, Your Honor. So to be honest, I don't have that amount. And I know Adriana mentioned getting out. I'm coming back to Texas on the 7th. I think 2 to 3 days should be sufficient for me to get all my stuff out. I will also pay. I can pay the 5,000 if that's an easy number for you guys. I can pay 6,000 too with that. I can't do that larger number to be honest and completely transparent. I'm willing to vacate that day though. Those days. I just need a couple days to get my stuff out, of course, and I will even pay the amount
Okay,
you're.
all right, I'm listening, I'm thinking, I'm calculating in my head.
It'll be back the 7th, Judge. Judge,
Oh.
if we can extend the writ out,
Uh-huh.
to allow him to voluntarily vacate with the judgment, I think it would probably be in his best interest to try to find someone somewhere else where he's able to use that money and be able to relocate. And, once the landlord-tenant relationship sours, it's just kind of hard to recover from that.
But you still want a judgment for those months.
Yes, Judge, just for the half of April.
Positions, yeah.
Right, Judge.
Which
And
is
then,
the April, 925, 1850 for June, 1850 for July.
yes,
1, 2, 3, 4. So that's why he's talking about 5,000, because any judgment I do today is going to include your unpaid rental, right?
right.
Maybe that's why he's thinking about, well, he could pay that too, because
Yeah,
he'd have a judgment hanging over his head in the rest of his life when you
Right.
abstract it for a 10-year period.
Right, but then too, Judge, he can also set up a payment plan with the property. They have a collections department normally that he can set up something that's more reasonable and affordable for him.
For
So
the
he can-
monetary portion of the judgment,
Exactly.
other than
So
the
he can get
possession.
that cleared off and be able to get that judgment released and be able to move on with his life and all of those things.
I'll be. Can I add a quick note real quick? I'll be
Yeah.
honest. I have that amount coming in on August 15th. I due to work. I'll just keep it simple. Due to work, I have that amount coming in August 15th. So due to guarantees from an international tour I'm about to go on, with clients. So I can pay that amount and in full. I'm more than happy to do so.
Or you
because
mean that whatever judgment amount that includes those months that they're seeking?
Yes. Yes, I'm willing to pay that. I just ask for time to get my stuff out. That's all I'm willing to take the judgment. I mean, it's
Okay.
not like
So it's like right now we're talking about
writ extension.
what commitments Ms. Higginbotham as the lawyer can make on how
Oh.
long she can wait
Uh-huh.
before requesting a writ of possession if you have not vacated. Ms. Higginbotham, what's the laid out date?
Right. Miss Mendez, he comes back on the 7th. Can we do the 14th to give the next week to be out and return the property and broom swept? When do your books close?
I leave state again on the 12th, to be honest.
Okay, so you'll be up before the 12th. So the 11th?
I leave state out on the 12th. If you can give me to the 12th because it's nighttime on the 12th, that gives me a final to get my cats, just so I have somewhere to keep my cats during the day. So can we say the 12th? Just
Is
because
that okay,
I have
Mrs.
somewhere to keep my
Rose?
cats.
Well, you're leaving the 12th.
Yes, to go to Michigan, and I will not be back in Texas for 2 years because I'm traveling internationally for a tour.
Okay, that's kind of what he's proposing as the
writ
date that he has to actually surrender the premises before you before you ask for a writ, Ms. Higginbotham.
Right.
Okay. All right, then the
Does
12th.
that work for you?
Yes, the 12th is good, Judge.
Okay.
Okay. All right.
For all those people that were saying, I wish this guy was in front of Judge Simpson, or I wonder what this guy would be like in front of Judge Simpson. You may get to see him. He's going to Michigan. And then apparently leaving for an international tour. Yeah. All right. All right, my dude. All right. Good luck on that.
Okay, then let me ask one other thing. The judgment will include those months that were not concession months. And I think out of curiosity for him, he needs to know, is that it, or do you have intentions to pursue him in the future for the loss of the concessions in a separate lawsuit pursuant to the contract addendum?
Normally, Judge, I have not seen it where the landlord would go after the tenant for the breach. Now, it will show on a final accounting statement that he would get within the 30 days and likely go to collections, but I haven't seen that they've sued anybody for that.
To actually get a judgment.
Right. So that would
Yeah,
just be
but
something.
that's true. In the end,
Right.
whatever's still on their ledger that wasn't paid through a court judgment,
Mhm.
Would go to collections, right?
goes to collections.
Right.
Yes.
Okay.
Right.
And then
And
you
you'll
deal
have
with
to pay that off.
collections to remove it off
Right.
your record, not with the court, not with the lawyers, not with the department.
Through the
Once they
collection.
send it to collections, they're done.
Right.
Understood.
And then they'll work it out with you and you can figure out payment plans and things. And collection departments are more flexible. They have the ability to be more flexible in their terms and conditions than we do here, or what Ms. Mendez would be able to do in her office also.
Understood. And yeah, I just want time to get my stuff out. That's my only wish, because I have ancestral stuff. We'll just put it that way. That's the
Well,
only thing I care about.
sure, we all have stuff.
I just
We
don't
will
come back
just-
until the 7th. I can't control that just because the airline won't let me change my flight. I would if I could.
Okay. So
Okay,
till the 12th.
all right. Well, typically, it sounds like two caveats here from
Mhm.
their end and your end.
Mhm.
You're asking them to give you more time before they would get a writ of possession on the judgment that I would issue today.
Correct.
Then they're also agreeing to give you that time because they could move forward with the actual writ. So typically, to add these conditions where I would say in a judgment, and a writ of execution would not issue until after this date, it's usually done pursuant to an agreement of the parties. I would have to have an agreed judgment between the parties to resolve this today, to give you that necessary amount of time that you need. And then it doesn't even need to include that you're going to make this $5,000 payment, but you understand what that means if you don't. It's going to be on your credit record.
Judge,
Yeah.
would it be easier if you just signed a normal judgment as you would? I'll put it in writing for you, Mr. Hake, that we won't execute the writ or seek possession
And
until.
obviously you can make some representations to me too, that I can, you
Yeah,
can add
Judge.
a note to the file. that
Yeah, Judge.
The court has been informed by the attorney that a writ will not be sought until after this date.
Exactly. Yes, Judge. And that'll be fine. That'll kind of help with the paperwork and all the back and
So
forth.
Ms. Higginbotham, tell me what the total is when we include the 925 half of April, the 1850 for June, and we're just within 3 days of the end of the month. So I'm going to not make you prorate July.
Thank you, Judge.
1850 for July. What is that total?
$4,625, Judge.
Okay. All right. I've heard enough. I understand that there might have been some legitimate disputes about
It caused the trickle down effect.
the concession, how it was, your first 800 was applied or not applied and what have you. But this is a long time for non-payment of rent for you to be in possession of some premises when somebody else, especially if it's a mixed property, mixed income property that someone else could be using that really needed it. A monetary judgment for $4,625 is not a lot of money for as long as you've had possession of these premises, Mr. Hake.
I understand.
And I'm inclined to grant it from everything I've heard here today. Their willingness to not insist that the judgment include the concessions at this time because they could. And I would be looking at the addendum. I would be analyzing it. I'm inclined to make a note in the file that a writ of possession at the representations of the attorney, Ms. Higginbotham, would not issue until after August 12th. Is that right, Ms. Higginbotham? Is that the date
Yes,
we're talking
Judge.
about?
Yes, Judge, that's correct.
Not before, it's after.
Right, after.
Not
Yes,
before.
Judge.
And that it grants them, the judgment today would grant them after trial possession of the premises and would grant them an unpaid monetary judgment of $4,625. Then you can deal with their office, with the office of this community for payment of that over time, or you can pay it completely quickly before it gets abstracted
Understood.
and goes on your record. Okay.
Understood.
Okay.
All
right.
And Miss Adriana, do you mind if we follow up with a call so I can offer one more thing to y'all after this meeting? Just because I have you here. I just wanted to ask
I can put you all
in a breakout
room to talk, so you don't have to make that phone call.
Yeah.
While we work on drafting and putting the judgment for me together.
Yes, please.
Thank you, Judge.
All right, Ms. Higginbotham, I will, and Mr. Hague, you need to address Ms. Higginbotham, not as Adriana, but as Ms. Higginbotham. You have never heard me call her Adriana.
Yes, ma'am. Yes,
that's just a title of respect for a woman, a professional woman, that people don't assume they can, especially if you're not friends. I mean, you don't know how many people will address me by my first name, and I'll think to myself, when did I give you permission to address me by my first name? You know, people that don't know me. And quite often.
All right, Elena. I mean, no disrespect to that. This has just gone on for way too long. But that is a very important thing. I believe in titles. I believe in, you don't say someone's first name. I hate it when people are in front of judges and call them, Fletcher comes to mind because people will be like, oh, okay, Fletcher. Like, okay, that's not, stop it. But, Judge Fletcher has been on my panel and he said that's not disrespectful to him. You call him Fletcher, you call him Mr. Fletcher, like he doesn't care. But it's still, I think, titles are important. You should absolutely use them. So this is a very important lesson. But still, Elena, calm down. We're all over this. Sorry. This is my apology, Judge Diaz.
Often it's just because they don't know the etiquette, right? It's not because they were being disrespectful. And I'm just trying to tell you in the future, when you're dealing with a professional woman or any woman, do not call her by her first name unless she's told you that you can, okay?
Yes, ma'am. I actually do appreciate that advice, genuinely.
Yeah, because, quite often, and I'm not saying you're very young, but you are, you haven't received the manners training in today's society that we used to get when we were growing up, Yes. I got it all at homemaking, home economics, mind you, homemaking, Future Homemakers of America. Okay. I got all my etiquette, all my manners, everything about setting a table, everything about furnishing a home, everything about the niceties of life and how you treat people respectfully. I learned from the home economics classes, but that training doesn't exist anymore.
No, I've never heard of that. So
that have to learn that as they go,
Right.
I've never heard of it, to be honest.
Well, yeah, there you go. You don't know. You haven't learned it. Nobody's told you. In the old days, they also used to have classes. It was called finishing school.
It was finishing school.
And it wasn't just for women. There was finishing school for young men too, because they grew up in very rich families and they had to have a proper behavior. They had to have proper manners, and their families would send them to finishing school. And co-ed finishing schools were better than anything else because you had gals there to deal with also. They would teach you how to dance and how to open the door for a woman, how to pull out the seat for a woman. All those old niceties that are like they just don't exist anymore.
Well, I definitely am curious about this. I'm definitely gonna do my research about this.
Yeah, it's just like go see, like, what if I wanted to have some training that used to be called finishing school? Where does anybody get that nowadays?
They actually still have etiquette schools and finishing schools.
Oh. Yes, because some parents, and then a lot of parents had no time to teach it. And they didn't have grandparents to teach it to, because it was the older I'm like a great grandmother, okay? I'm the kind that could teach a young, but only if I had enough time to spend.
A little quick, info about me. I was in a fraternity in college, in that fraternity, they actually sent us to etiquette, like an etiquette class. To be part of this fraternity, you had to take this class. Now, I was raised properly, so the class was, just telling me things that I already knew. But the amount of people that were around me that didn't understand, proper etiquette did blow my mind. I will say that. So the judge is right on this, but why are we talking about this now?
With them, all
Right.
that's gone out the window. People are living all their lives online on our devices, and our young people are not learning that. But if you're a professional in the professional world, you need to know a lot of the etiquette and manners. Okay.
For sure.
Thank you, Mr. Haig.
Of course.
So I'll be issuing a judgment today on behalf of the plaintiff to recover possession of the premises with a monetary judgment of $4,625, an unpaid rental. And I'll make a note to myself that that's for the half a month of April when the first concession ended. And after the second concession ended, for the months of June and July, and the sum of $1,850 for each of those months. And that the plaintiff's attorney has represented to the court that a writ of possession will not be requested until after August 12th.
Right.
Not before August 12th. August 12th or after it could issue. But remember, issuance means they have to come, they have to pay for it.
Yeah, credence to Mikey. I've actually seen you in a lot of thumbnails lately. Sorry, when I say credence to Mikey, let me rephrase. Mikey, I've seen you in a lot of thumbnails lately. You've been, I don't know, a police officer, a firefighter, just a random civilian. And I think I saw you on a motorcycle recently too. You're all over the place, man. Credence to Mike. I don't know why I say credence to Mikey. It's Mikey here. Credence isn't gonna come here. Mikey, thank you so much for hanging out with us tonight. I do appreciate it, bud. Go check out Credence and Mikey. You've probably seen them. They've got about 47 channels. So you probably at least are subscribed to one of them. So you're already in the right. You're going in the right direction. I love you, bud. I really do. Oh, fantasy football is starting. So you playing? You playing this year, Mikey?
We have to issue it. The judge has to sign it, so it could take another day or two,
Okay. Understood.
And good luck on your move and your cats and your antiquities or things that mean a lot to you, because it takes a lot to hang on to those things. Because I've had a sister that lost a storage unit.
Yeah, a couple of items are from the 1800s from family.
Yeah, that she just, and her living room was a living room that I had passed on to her that I had only used for a few months, but then I decided I didn't want leather furniture. And she lost a living room set that was close to $2,000 because she didn't pay her darn storage unit,
Yeah, that.
And I was married at the time, and I had a husband that really didn't care to support my paying all those things for family members,
Right.
And so she didn't come to me for those things anymore while I was married, and my husband's deceased now. But there you go. That's why I'm a great grandmother, because I'm a great grandmother to actually my husband's great grandchild.
No, you couldn't. No, you couldn't. She would talk to you all day. Don't lie. Don't lie.
All right. Thank you very much. And I'll
Put us
be
in the breakout room, please.
Yes, I'm going to put you in the breakout room while we work on the judgment. Thank you.
All right, I was muted. I did actually end the video here. She goes on for the next 10 minutes talking to her law clerks. I don't know anyone who's in the building. She's just talking to nobody. And then these people do go in a breakout room and they come back and they're like, "Hey, are we excused?" And the judge gives them another story before she says they're excused. But I didn't want to put you through that. We went through 2.5 hours of this amazing judge. She is super sweet. I would absolutely love Judge Diaz to be my grandma. I would I'm not going to replace my grandmas with anything because they were amazing. But if Judge Diaz was my grandma, I would absolutely sit there and listen to her stories and just probably make fun of her the entire time. But that is it. We made it through the entire thing. I didn't think we would. I was going to make this a 2-night thing. We went 2.5 hours. Yay! Yay! You guys are awesome. Thank you so much for hanging out with me tonight. Oh man. Biggin, thank you so much for the raid. I can guarantee Biggin's passed out. So he's no longer here. But thank you for everyone that came over from Biggin's channel. Also, Mikey, thank you for hanging out tonight. I appreciate it. Yeah, great. Awesome. Great to see you. And fantasy football does start soon. I saw the yes. We're gonna have to have a new roster of fantasy football players this year, though. I gotta kick out about half the league, so we gotta get on that. Training camp just started. We got about 2 months. We got this. We can do hard things. All right, you guys are awesome. Mods, thank you so much for your hard work tonight. Thank you so much. We had a little bit of drama at the beginning of the stream, but you know what? You guys always words are hard. You guys always take care of it. Thank you so much. I do appreciate it. And very rarely do you have to listen to me actually tell you guys to calm down because my mods are awesome. You know what? We just had someone who decided to make their voice heard and they didn't like it. Anyways, that's all I have. It is 10:30. Is Lone Wolf still on? Can we raid Lone Wolf? Lone Wolf sent me a very good video this morning. So hopefully he's still awake and live streaming. Yep, he is. He's still on. All right. For anyone who doesn't know, Lone Wolf sent me my video that I released this afternoon because Judge McNally decided to delete his stream. He never does that. And I was halfway done with my video, and all of a sudden, blip. But Lone Wolf always got my back. Lone Wolf always got my back. Ah, man, words are hard. Lone Wolf always has my back, and he was able to provide me with the clip that I did not get. So we're gonna go rate him. Make sure to tell him hi. You guys have a great rest of your night. Tomorrow is Thursday, so it is yoga night. I will be an hour earlier. Yeah, that's all I got. I think I said everything. For anyone who's donated to No Nose GoFundMe, thank you so much. I haven't refreshed it since I started my stream tonight. So, but if anyone did donate to that, I do appreciate it. I know he appreciates it. That's all I got. I prolonged this outro as long as possible. You guys have the best night ever, and I'll see you tomorrow. Okay, bye.
Thank you.